Hmm. Yes.
Yes. May I please, Your Lordship? Lordship, I'd like to mention for listing in motion, my lord, on Thursday, my lord. Because, my lord, already we have filed the
You
application,
approach the registry for that.
my lord, for motion, my lord.
I know. Approach. Next.
I get to answer number 28, my lord. What because in this case, justice service was permitted by the Supreme Court. We took the justice service, but unfortunately, we failed to file the affidavit. 2 days time will be granted to file the affidavit.
28.
I did 28.
Why is it listed for orders?
Only because of that, we did not file the affidavit of service of notice upon the respondent by justice service. That affidavit does not file. We file within 2 days, but also 2 days time.
Okay, as paid for by Mr. I.S. Saikia. 2 days time is granted for filing affidavit showing dusty service to respondent
Private respondent, the principal of the school,
to the private respondent.
to
The private respondent number 4. List again after a week on a date to be fixed by the registry.
May I praise the Lordship?
Yes.
Lordship, I'm praying for listing of 3 matters tomorrow. Lordship, the urgency is that the petitioners therein, all 3 of them are doctors undergoing their PG course. They had secured admission in the year 2023. Now, Lordship, on 7th and 8th of August, they were served with an order that their PG seats have been cancelled and they have been asked to vacate their hostels immediately. Lorships, no reasons have been assigned, no prior notice before such cancellation. Out and out, an order has been issued towards cancellation of their seats secured in 2023, and they have already completed around 2 years of the course.
You approach the registry for that. It's a motion matter, isn't it?
It's a motion matter. We filed it yesterday. Lordship, considering the urgency only.
What is the urgency?
Lordship, the urgency is that seats have been cancelled.
Cancelled already. It's not that it's going to be cancelled. It's already
No,
cancelled.
Lordship, it has been cancelled. The order has been issued on Friday without giving us any opportunity of hearing. Now we have been asked to. There are no reasons assigned at all in the order. Not even a single word as to why my seats have been cancelled.
Anyway, you approach the registry indicating the urgency. Okay, they'll accordingly adjust. Lordship. Yes.
Lordship, I have to mention item number 8. Lordship, I want to withdraw because the matter has become in absence.
Item 8.
Yes, Lordship.
Your good name?
R.A. Ahmed.
Mr. R.A. Ahmed, learned counsel for the petitioner, submits that the matters become infructuous. And accordingly, matter may be disposed of. Stop. Then who's appearing for the other side? Mr. S. Kaur, Miss S. Kaur, learned government advocate, appears for respondent numbers 3 and 5. 3 and 4. 3 and 5. Okay. Anybody else? And agrees to the submission. Okay. 3 and 5 and agrees to the submission. Stop. In view of above, with petition stands disposed of as infructuous. Yes.
Maybe, Lordship. Lordship, I like to mention one item for listing.
For listing, please approach the registry.
Lordship, last 1 month, Lordship, I approached the.
No, you approach. You write in the register. They'll give you. They'll accordingly. We have given instructions to them. Yes.
This is my lord. My lord, with respect to item number 14, my lord. We have received our department instructions, my lord. I'm praying for some time to file our affidavit.
You are for SSA.
SSA, my lord, respondent number 2.
Who's for the Botakur and P. Bora? Have you informed them?
Yes, my lord.
Lordship, I'm for the petition.
Any objection? How much time?
1 week time, my lord.
Your good name?
H. Burwa, my lord.
Mr. H. Barua, learned standing counsel, SSA, submits that he has received instructions and may be granted a week's time to file counter affidavit. Praise allowed to list again after 10 days.
Lordship, may I pray for a date, Your Lordship? 2023 matter.
They'll give a date. List again after a week on a date to be fixed by the registry. Yes. Yes, Mr.
Yes,
What is the instruction?
I have received the instruction. Yeah, my lord. Respondent number, petitioner and respondent number 4 has a rift, my lord. There is tussle between them, my lord. And allegation and counter allegation is lodged by both of them. And ultimately hearing was conducted by the director. And Accordingly, my lord, here. So here, my lord, I Inspector of School has submitted a proposal to the director for transfer the respondent number 4 to another school, my lord. This is my instruction, my lord.
Proposal, when was it sent?
It has not mentioned here, my lord, but the proposal has been sent for transfer of Srimati Deepa Das to another school to the Director of Secondary Education, Assam, in the interest of smooth functioning of the school.
Date is not given,
Mm,
only saying that the proposal is sent.
Yes.
Inspector of school of which area? Tezpur?
Tejpur.
Yes, Mr. Counsel.
Yes, your lordship, Tejpur.
See, one thing which I just went through this, your writ petition.
Yes, your lord.
Question is whether this writ petition is maintainable. Director has, somebody has written to the director.
Lordship, it is forwarded
Okay.
from the Minister of Education. Your
Maybe then you go to the minister. Why do you come to the court?
Lordship, that was forwarded and accordingly, direction has been issued by the respondent number 2.
See, now director has written to the inspector of schools. Inspector of school is not complying
Yes, sir.
and you're coming to the court to execute the order of the director. Is it possible like that?
Lordship, simple prayer is that to conduct an inquiry. And
No, no, no.
Your Lordship, the proposal has.
Who are you, by the way? Who are you? You are only a member of the, what do you call it? What
Yes,
committee?
I was the.
Governing
president.
body.
I was the.
What right
president.
do you have?
Lordship, for concerning the smooth functioning of the school, your Lordship, there are.
No,
the
no, no.
duties and
That you take it up with the authorities. You cannot come to the court just like that to transfer somebody from one school. It is not that your right is affected. You are not a candidate for that post. You are only a caretaker sort of thing to look into the welfare of the school and all that. So for that remedy lies with, there are several procedures within the department. You have gone to the minister. Go to him.
Lordship,
Nothing is
at the
done.
fag end of the entire dispute, your Lordship, the petitioner was bound to approach the minister, your Lordship. And thereafter, direction has been issued, your Lordship, by the respondent. number
We'll
2.
close the matter.
Yes.
Your good name?
I'm KJ Saikia, your Lordship, on behalf of Mr. P. Bodlo, your Lordship.
I'll record your name.
Yes, sir.
Mr. KJ Saikia appears for the petitioner, while Mr.
On
U
behalf of
Sharma,
Mr. P. Bodlo.
not required. Mr. U Sharma appears for the Department of Secondary
Yes.
Education.
1, 2, and 3, my lord.
Stop. This writ petition has been filed by the petitioner, who is the, what is he?
He was the president of the SMC, your Lordship.
Was,
Was,
not current.
not current, your Lordship.
Who was the president of the school managing committee of
The entire SMC was compelled to resign, your Lordship.
what is the name of the school?
It is Tejpur Collegiate High School, your Lordship.
Where do you get that?
Lordship. That can be found from one of the letters. Your Lordship, at Annexure H, your Lordship.
This is the problem, you see.
Annexure H, your
You
Lordship.
should have arrayed the headmaster or principal or whoever of that collegiate high school also as one of the respondent. What did I say? Who was the
President of the SMC.
president? Who was the president of Tejpur Collegiate High School?
High school.
And the grievance expressed is against the present incumbent principal, headmaster.
Assistant headmistress.
Oh, okay. Present incumbent assistant headmistress. Who is said to have failed to maintain academic discipline due to negligence of duty. Stop. A complaint was lodged by the petitioner and the other members of the managing committee, and pursuant to which the director of secondary education ask the Inspector of Schools, SDC Tezpur, to conduct an inquiry as per the rules and to take appropriate action. Write his letter dated
125.
7/1/25. Not his, but her, I think. Mamata is lady, isn't it?
Yes, sir.
Write her letter dated 7/1/25. Bracket annexure 1.
Annexure I.
Page
Oh, this is I, annexure I,
yeah, I,
capital I.
page 32.
Stop. Since no action has been taken thereafter, the petition is before this court. Stop. Next para. On 16/6/2025, when the matter was listed, this court asked the Standing Counsel, Secondary Education Department, to take instructions in the matter. As regards to the steps taken pursuant to the letter dated 7/1/2025 of the Director of Secondary Education, who stopped today, Mr. P. Sharma, Learned Standing Counsel, Higher Education. U. Sharma, Learned Secondary Education Department submits that as per the instructions received by him, the Inspector of Schools, Tezpur, has made a proposal for transferring the respondent number 4 to another school. And the outcome of the said proposal is awaited. To stop since you cut that, it therefore appears that some steps have been taken pursuant to the communication dated 7/1/2025. And having regard to the nature of controversy, this court is not inclined to proceed with the matter any further. In the matter, and accordingly, the matter stands disposed of.
Lordship may kindly record if the proposal has been acted upon or some observation.
It is up to them. No more observations required. They have done the needful, so it will come to a logical conclusion. Yes,
Deeply obvious.
next. Okay.
Please, your lordship.
Yes,
Lordship, can you please fix the meter for time being? My senior is in the next court.
who's your senior?
SD Purkastan.
Why is it listed today for orders? And who's for the respondents?
But I had no role, my lord. Here, my lord, NC is the main authority to decide regarding this. But,
Writ petition was dismissed.
my lord,
Now they have filed review. Writ petitioners have filed a review petition. Anyway, let him come. Let your senior come. Last timing.
Much obliged.
In this case, writ appeal is pending, my lord. Writ appeal number 148/2029. It is fixed on next month, in the month of December, September.
148 of
148 of 2019.
writ appeal against which order?
Order passed by this honorable court, my lord. It was actually dismissed the petition earlier. Similarly situated person, they approached the writ appeal, my lord. Then I have filed this case because since the writ appeal is pending, as soon as the obtain the order passed by this writ appeal, then this matter will be kindly be taken up, my lord. I have mentioned, my lord, in kindly peruse the item number 2 or for 2, no? Benito. Yeah, my lord, I have mentioned in lordship kindly peruse the page 19.
Of which writ petition?
That second one, Benito Kotuki and here the
19,
is it 2, 3. Item number 3.
item 3.
Page 19, para 24. It is already mentioned in the order statement. Ujul Haq Ahmed. There are lots of writ petitions. Of course, it has been fixed on next month for hearing. It has already been heard earlier, my lord.
So when do we list these matters then?
It will be fixed next month, my lord. So after, your lordship kindly fix this matter after passing the order of this writ appeal, my lord.
No, we don't know, no, when the writ appeal will be disposed of.
3 weeks then, my lord, after 2 weeks, because it has been fixed in the next month. In the month of September.
You are for
That
the,
is code number 1.
you are for the petitioners in all the 3 cases.
Yes.
Please write Mrs. K. Devi, learned counsel appearing for the petitioners in all the 3 cases, happens that in a case of similar nature, the writ court had dismissed the writ petition and the petitioner had filed writ appeal number 148 of 2019, which is due to be posted in the month of September for hearing. Stop. She submits that the outcome of the said writ appeal would cover the present 3 matters, and therefore these cases may be listed after 4 weeks. To stop. Next para in view of above, matter stands adjourned for 4 weeks. Ms. P. Das, learned standing counsel, secondary education, appears for the respondents. Respondent department. Respondent secondary department.
Obliged.
All right.
I'm deeply obliged.
The matter will send for mediation was.
Who's for the other side? Elementary?
Here, my lord. We have received that second one.
What is the instruction?
Here, a hearing was conducted, my lord. There after the.
This is regarding what?
Pension proposal is submitted before the.
Regarding pension, claim for pension? Claim for pension by whom? The pensioner or legal heads?
This is, here's lordship, this is here lordship,
The heirs.
yes. His wife lordship, his wife. Pension is also a party lordship.
Hmm?
Pension is also their party loss, director of pension.
So hearing was conducted. Then
Option for
authentication of birth as per health system and so submit so. Uh, Deputy Inspector of Schools, Sadia.
Here submitted this proposal before the
Yes, sir.
director pension matter.
Who has sent? DIS?
Deputy Inspector DIS Sodia.
Okay. So this is the stage, Mr. Counsel. DIS Sadia has sent the pension proposal to the Director of Pension Assam.
pension shall bring the instruction, what is the present status of it? That pension shall bring the Department of Pension.
Of course, now you still want to refer the matter to mediation?
Not to the lawsuit, let them bring the instruction lawsuit pension.
Yes.
Or your lordship, since the proposal has been submitted, your lordship. Proposal has been submitted by your lordship, by the parent department.
You obtain instructions. We'll give you some time.
That can be done, or otherwise, if he is eligible, pension may be provided within 3 months, that may be. Because since the proposal has been submitted,
You want me to dispose it of?
can be done so within an outer limit.
Now let them pass instruction lawsuit, like, and if
Yeah.
they'll say something lawsuit, then I will be even back lawsuit, so. That letter may be pending, that will be this. Matter will be pending lawsuit, then in the meantime, they,
Okay.
Your good name.
KD Sharma lawsuit.
Although Mr. KD Sharma, learned counsel for the petitioner, is prepared for mediation. Mr. PK Bora, learned standing counsel, elementary education, on instructions submits that the Deputy Inspector of Schools, Sadia Chapakoa, white letter dated 23/6/2025, has submitted the pension proposal in respect of late Lakshinath Borgohain. Who is he? Father,
No,
Husband. Husband of the petitioner, to the Director of Pension Assam for settlement of the case. To such being the position, from it appears that some steps have been taken to consider grant of pension to the petitioner. Gustav. Mr. B. Deori, learned government advocate, representing the Director of Pension, Assam, shall obtain instructions in this regard by the next date. List this matter again after 2 weeks.
Yes.
On a date to be fixed by the registry.
Date may be fixed lawsuit.
The communication dated 11/8/2025, produced by Mr. PK Bora, Standing Counsel, Elementary Education Department, shall be retained in the record and marked as X for identification. Okay,
Date may be fixed lawsuit if possible.
registry will fix the date
Lot.
after 2 weeks. Yes, secondary. What is the instruction?
Lordship, here our instruction is that from the pension department, your lordship, that no such pension proposal in respect of people count has been received, your lordship. So if on receipt of that, we'll do the necessary. Our department stand here, your lordship. So the petitioner or either the department has to.
I have to take instruction here. Instruction is available.
Because
There is something to be done also, that suspension period is also there. Suspension period, so whether it should be regularized or not, that will have to be determined, then only pension will have to be calculated.
So I have to take it.
How much time?
2 weeks, my lord.
None appears for the petitioner when the matter is called. Mr. U. Sharma, learned counsel, appears for the secondary education department. And Mr. B. Diori, learned government advocate, appears for the pension department.
I'm for 6 or 2 and 3. 2 and 3.
Who are they? 2 and 3.
2 and 3, 2 is PPG and 3 is director of pension.
Ah, appears for the respondent numbers 2 and 3, okay. As paid for by the learned counsels for the respondents. Further 2 weeks' time is granted to obtain instructions in the matter. List again after 2 weeks on a date to be fixed by the registry. Yes, Mr. Padgiri.
The matter pertains to non-payment of death benefit as well as arrear family pension left by the mother of the petitioner. Since the case was filed in the year 22, no affidavit has been filed in that manner.
Yes, Ms. Kaur.
Bring to just 2 weeks accommodation lordship to obtain the instruction. So it is still awaited, okay.
All right.
I have no objection if you refer the matter before the mediation. I have no.
Oh, this is for mediation, isn't it?
mediation matter.
Should we refer it or what?
No, lordship, I need to obtain instruction first, lordship.
Although Mr. K.R. Padgiri, learned counsel for the petitioner, is agreeable to get the matter referred to, get the matter referred for mediation. Ms. S. Kaur, learned
Standing council lordship here,
standing counsel,
elementary education.
elementary education
One-
department submits that she may be given 2 weeks' time to obtain instructions in the matter. In view of above, matter stands adjourned for 2 weeks to enable learned standing counsel to obtain instructions. List again after 2 weeks on a date to be fixed by the registry.
Obliging.
This matter kindly adjourn for the day, my lord. Learned counsel is out of station, my.
Who is out of station?
M this,
Des or Das?
MS M Das.
Ms. M. Das, learned standing counsel, learned counsel for the petitioner. Is said to be out of station. As paid for on our behalf. Matter stands adjourned for the day.
Obliged.
Instead of adjourn, you have passed over for the day.
My lord, in this case, my lord, kindly peruse the order dated 16/2/2024, my lord. The government advocate, my lord, Mr. T. Soika, taking time, my lord, to receive instruction, my lord. Yes, because we have pension proposal pending before the director of pension, my lord.
Yes,
Here we have sent the pension proposal to the director of pension on 22/11/2023, 23.
Kindly peruse the, my
And
lord, page
Service
36.
book
my lord.
also submitted to them.
that was in the year 2023.
23, my
What
lord.
has happened now? Almost 2 years.
My lord.
Mr. Diori?
Yes, the Lordship,
Any instruction?
our instruction on 8 October 2024 is that we have requested the inspector of schools for relaxation of that rule 205 and 206, which will be required in this case, your lordship, because proposal has been submitted after a lapse of 35 years from the date of retirement. So some
35
relaxation-
years.
Yes, after 35 years. It speaks so this communication.
What is that rule?
Rule 205 and 206 of the Assam Pension Rule 1969.
What does it say? The rule?
Lordship, when the proposal is submitted after the gap of, after some length of time, your lordship, so there needs to be the relaxation of that particular rules by the.
We have sent to the director.
We have sent it to the inspector of schools that you get the relaxation of this particular rule and send
Inspector of schools of,
to inspector of schools of Barpeta.
yes, who is appearing for inspector of schools?
I am-
You're there. So what is the instruction there?
Regarding this letter, I have no instruction right now, so my lord, I have to take instruction from the inspector of school.
Please write, Mr. B. Deori, learned government advocate, appearing for the Director of Pension, submits that since the pension papers have been submitted 35 years after the retirement of the employee concerned, relaxation is required. A relaxation clause has to be invoked, and for which a letter has been sent to the Inspector of Schools, Borpeta, to do the needful. Stop. Mr. U. Sharma, learned standing counsel, Secondary Education Department, submits that he may be given 2 weeks' time to obtain instructions in the matter. Considering the submission, matter stands adjourned for 2 weeks to be listed again on a date fixed by the registry.
Offline.
Lordship, matter pertains to non-payment of family pension loans by the service rendered by deceased son of the petitioner.
Okay. Family pension. So what is the, any?
The age of the petitioner when the writ petition was filed was 94 years. It's alive. Just wanted to confirm.
Well, he must be a healthy man.
Lady Malo.
It is not every day that we come across.
So far as I'm concerned, I paid for the accountant general. So I have no role to play in the matter, Melon. The pension benefits should be covered in the new pension scheme. And accountant general office, they don't deal with the new pension scheme matters.
From our side, your lordship, the secondary education, your lordship, affidavit has already been filed, your lordship. And the respondent number 6.
What do you say in the affidavit?
Your lordship, paragraph 8.
Petitioner is not eligible.
Your lordship, respondent number pertinent to the death of Jiten Mudoy, his wife Srimati Rekha Bora, that is respondent number 6, reportedly got remarried to someone. That's why your lordship, pertaining to that facts, your lordship, reflected in the Honorable High Court order dated 21/12/22. Further, the same is reflected in the representation dated 26/9/2012. Which has already been annexed as Annexure 8. And therefore, your lordship, as per the rule, your lordship, the instant case is covered under new pension scheme. And that respondent number 6 is not eligible for family pension. We have stated in our affidavit in paragraph 9, and that is reflected in the page 34 of our affidavit in opposition.
So what about the petitioner? Is he eligible? Respondent number 6 has not filed the writ petition. Petitioner is claiming pension.
As per their affidavit, lordship,
Hmm.
it is stated, rather it is to be paid to the eligible next of kin.
Next of kin,
That
your
is
lordship.
petitioner,
That is also, your lordship, we have stated in paragraph 10,
Page number
34 itself. Last paragraph, your lordship,
34.
paragraph 10. That the inspector of school, North Lakhimpur, to submit proposal for family pension, pensionary benefits along with relevant documents in respect of the eligible person as per the next of kin of late Jiten Mudoy, which is expired headmaster in connection with the instant present writ petition. Immediately, the deponent issued a letter number so and so dated 30/10/2023, asking the headmaster Kosua MP High School, Dokhin Dholpur Girls High School is now amalgamated with Kosua MP High School, to submit proposal within 3 days without fail. In continuation, your lordship, that is page 35, the reply from the headmaster is awaited, and only on receipt of the relevant records regarding next of kin, the deponent would be able to forward pension proposal. Your lordship, I need to.
Who is the deponent?
Your lordship, that is DSC, your lordship,
The opponent is Inspector of School.
and inspector of.
Lakhimpur.
Your lordship. Yes, Your
Inspector
Lordship.
of School Lakhimpur has filed this, respondent number 4.
Yes, Your Lordship. And
Now,
now we
head-
have awaited. for
headmaster is
notice.
impleaded as a party.
Yes, Lord.
Respondent number,
7.
who is appearing for respondent number 7? You say pro forma respondent. Notice is served or not?
Sir.
Hmm. When? How? Petitioner is the mother.
Mother.
Anybody else in the family? Apart from mother,
Brother is there, Lordship, younger brother.
younger brother is not eligible, not eligible for pension. Mother is eligible. Mother has received GIS. Only GIS, isn't it? What is your instructions? How much have you received?
Bye.
This is your case. It's nobody's case. It's your case. You should know how much you have received.
Sorry, Lordship. 3 lakhs. It is stated there are 3 of the petition.
3 lakhs as GIS.
Lordship. Page 5.
Now question is where's the headmaster of that school?
Headmaster has its role, Your Lordship, so he has to appear, Your Lordship.
Where is the headmaster? No, whether notice is served or not.
Notice citation, so.
Can you serve notice by Dusty?
Lordship.
What is to be done?
You can, Lordship.
Unless he appears, it will be difficult to pass order also.
Order is 8/11/23.
8/11/23.
Looking to double testimony.
8/11/23 is what? Respondent number 6 took time, that's all.
Sorry.
We are asking about respondent number 7. And you have made him a pro forma respondent. He will say, I'm only pro forma. I will have nothing to do.
Its role, Your Lordship, the affidavit itself reflected.
As
All the
have
relevant
given
documents he has to submit.
We can serve what you last year. Or we can. Since it's still mentioned.
Where is the letter of the inspector of schools? Let us see. Against your statement. Headmaster, Kachua MP High School. This is located in Lakhimpur.
Looking.
I will be allowed to serve Dusty, Lordship. Upon
Dusty.
respondent.
How much time will you take? 10 days? 1 week or 2 weeks or 10 days? 2 weeks. See, don't delay.
Lordship.
Petitioner is 97 years now,
2 weeks. 2 weeks.
but with God's blessing, of course, she will be healthy, no doubt, but you should not delay.
May I make it clear, my lord? The name of the accountant general may be deleted from the array of parties because I have no role to play in the matter.
Why not?
Because my lord, and
They will submit proposal, then they will forward to the AG, then you have to do it.
she was a teacher, it was the pension and public grievances department, not to the AG members.
Is it so?
Yes, madam.
We'll see that at some time. Let us, at this stage, let us concentrate on notice to respondent number 7.
The rule is, pension matters relating to provincialized employees are dealt with by the pension and public grievances department.
Please write down the petitioner. Who appears to be (94) years old at the time of filing of the writ petition, has filed the instant writ petition claiming family pension in view of his son having died in harness on 5/12/2016 while working as an assistant teacher of Dakhin Dhalpur Girls High School of Lakhimpur district. Stop. Respondent number 6 is the daughter-in-law. But from the affidavit of the department, it appears that she has remarried. And it is only the legal heir of the late employee who will be entitled to family pension. Which should include the mother of the late employee. Stop. It is also stated that apart from receiving amount of rupees 3 lakhs towards GIS, no amount has been received by the petitioner. Stop. The affidavit of the Inspector of Schools, LDC, North Lakhimpur, goes to show that the headmaster of Kasua MP High School, bracket respondent number 7, has been asked to submit proposal for family pension and pensionary benefits on 30/10/2023 for onward submission to the Director of Secondary Education, Assam, within 3 days without fail. Stop. However, it is seen that notice has not been effected on respondent number 7 till date. Stop. Since the presence of respondent number 7 is crucial for determination of the case, the petitioner is allowed to serve notice to respondent number 7 by way of Dasti within 2 weeks from today through the registry of this court. Stop. Once Dasti notice is served, the petitioner shall file an affidavit to show proof of service. List the matter again. After 3 weeks,
After 2 weeks.
2 weeks.
Lordship, I'm sorry, Lordship, I have wrongly
This is a
submitted.
correction, my lord.
Respondent number 6 received rupees 3 lakhs, yes, Lordship. Petitioner has not received.
Okay, that 3 lakhs part you cancel, not required then. Who's respondent number 6? The wife?
She's not eligible, your lordship, because she already married someone else, your
No, no, we're not talking about the pension. She's talking about the GIS. She has received it.
For respondent number 580.
list the matter again after 2 weeks on a date to be fixed by the registry, huh? Mr. B. Sharma, Nanat, Standing Counsel, AG Assam, appears for the respondent number 5. Yes, Mr. Diori? Anything? You look very concerned. That's why we have 2 weeks.
97.
She's 97 now.
Which are relating to excess withdrawal method as well as the pensionary benefit measure. But your lordship will find the case 38 minute. This is the letter communicated by the inspector of schools to the director.
Okay, see, the matter is listed under that mediation column. Should it go to the mediation for mediation?
Instruction is required from my side.
From?
But instruction from the client is
Is
required.
required. Ms. Burman, what do you say?
Can this for the mediation?
Excess drawal.
Yes. So do the pensionary benefit. It is 3,26,000. As per the notification, they can find 3 lakhs, but as per the order of the Supreme Court on entropic machine, there is no limitation. They cannot only 3,26,000.
Lordship may fix it in the next week, lordship. Of the instruction.
Are you still in service or you retired?
Retired, lordship.
Retired. This is excess drawal from what? Wrong fixation of pay
Yes.
or what? Don't say yes like that. Just see, make sure.
Yes.
Wrong fixation.
Wrong fixation of pay. Then Rafiq Masi should come into play.
Yes, my lordship.
That's what. Why go for mediation when the law is settled?
Yes.
If the facts are correct, if it's a wrong fixation of pay, wherein you had no role,
Yes, sir.
you have no role in fixation of pay.
This 38.
It is the officials who will, respondents who will fix the pay.
Yes, my lord.
So you're not responsible.
This 38.
Page 37, my lord, your lordship will find.
Page 30,
Wrong fixation to be 1,685, lordship.
page.
This 38, lordship.
38.
Yes, my lord. It is the letter of the inspector of schools.
What is their citation, Rafiq Masi?
Yes, my lord.
Yes, it's
2015, lordship, 4 SCC, 334.
2015,
4 SCC.
334.
Double.
What is the petition? What was the petitioner working as?
Lord,
Assistant teacher.
assistant teacher.
Where?
Retired assistant teacher. Your lordship will find this.
Come to your synopsis. Joined service in 74,
Yes, my lord.
stipended teacher. Then regularized in 74 only
Yes,
and confirmed in 89.
yes, my lord.
He retired in 2017.
Yes, my lord.
Then your pension is not finalized
Not finalized.
because of this
Because of
wrong
this.
fixation. Excess amount is 362,248.
Yes.
And who has given this letter an extra I? This is by the
Inspector.
Deputy Inspector of Schools. After this, what has happened?
Nothing has happened, my lord. Pension is pending, my lord, and writing is also pending, my lord.
What does Rafiq Masi say?
It was civil fine, judgment. Is 345 minute, last paragraph 18 minute.
You're covered by which one?
Millet.
Roman 1, 2,
Roman
3,
one
4.
minute.
Roman 1.
Yes, millet.
You belong to what? Class 3?
Class 3 minute.
Class 3.
Yes, assistant teacher. Moreover, my lord, there is a notification of finance department, my lord. Dear lordship will find page 41, my lord. They can waive 3 lakhs, my lord. Next notification, my lord, page 41, my lord.
They can waive?
Sorry, my lord. Page,
Director of pension lordship, waive rupees 1 lakh lordship. Now lordship, as per lordship cabinet decision, the director of pension waive up to rupees 3 lakhs. As per notification, page number 40.
page number 39, my lord, and excerpt J, my lord. This is the notification issued by the.
Type
finance
copy.
department. Yes, this is the type, my lord.
39 or 42?
Notification, and 39 is the type copy.
Yes, my lord. 42 is the original, my lord.
Which part?
My lord.
First paragraph
part.
one, how is first
How-
paragraph?
Hmm.
When the waiver of recovery in above mentioned situation is considered, pension public grievance department is empowered with financial ceiling of rupees 1 lakhs in each individual case where recovery is to be waived. And beyond rupees 1 lakh, the excess approval of finance department is to be obtained. But pursuant to the cabinet decision dated 28/10/2021, it has been authorized to the director of pension for waiving of excess drawal up to rupees 3 lakhs in respect of provincial school teacher and PRI exclusively with the following conditions as summarized by the Honorable Apex Court. That's the 18th case of Rafiq Masi lordship. After Rafiq Masi lordship, this notification was lordship.
Okay. Then this amount excessive drawal is more than 3 lakhs in the present case. It's 3.6.
In Rafiq machine, there is no limitation for the amount, madam.
But the government has came up with a notification.
Approval of the finance department is required, lordship. It is above 3 lakhs, lordship.
Ah.
After 3 lakhs, director of pension can waive, lordship.
Where approval of the finance department? Where does it say that above 3 lakhs approval has to be taken?
However, lordship, the paragraph, lordship. But lordship.
Where?
But pursuant to the cabinet decision
Hmm.
dated 28/10/2021, it has been authorized to the director of pension for waiving of rupees royal up to rupees 3 lakhs
Hmm.
in respect of provincial school teacher and PRI exclusively with the following conditions as summarized by the Honorable Apex Court in case of State of Punjab versus Rafiq Masi. In December and was decided by the Honorable Court on 18th of 2020, wherein recoveries of employees would be impermissible in law.
So that I've seen.
Yes.
You were saying that above 3 lakhs permission of the finance is required.
Only lordship, I'll leave it up to 3 lakhs lordship for director of pension.
I know that.
Yes.
It says 3 lakhs.
Yes.
But you just said that if it is above 3 lakhs, finance permission is required. Is it given in the notification like that? Not, there's nothing like that.
Yes.
And Rafiq Masi has not given any high ceiling.
Yes.
It should be within this limit. It doesn't say that.
Yes, sir.
So why this notification has been issued in such a manner?
Because lordship, earlier lordship, 1 lakh is lordship permissible limit. Lordship, in this case, Lordship, finance department is also party, Lordship.
Yes, Ms. Barua, what do you say?
Lordship, as per the thing above 3 lakhs, finance approval will be required, your lordship. And for that, the proposal has to come from the parent department, and then we'll consider and we'll pick up for you.
Who says that?
As per the notification, your lordship.
Where?
Finance
Where?
approval is required, your lordship.
Where? Point out.
One finance officer.
We'll go by Rafiq Masi. There's no such limit.
Because we are a ministry time.
But it is only mentioned in respect of rupees 1 lakh, Lordship. Then the approval of finance department is to be obtained, Lordship, that was different. But in case of,
That
No,
beyond 1 lakh,
yes,
beyond 1 lakh, finance department. Thereafter, what continues is that as per the recent cabinet decision, this ceiling has gone up to 3 lakhs, that much. And there is no such kind of provision saying that beyond 3 lakhs, again, you have to come to the finance department. Nothing like that.
it is not clearly mentioned in the Lordship session notification, Lordship.
So we'll dispose it of in terms of Rafiq Masi. Third, Mr.
Islam.
R. Islam, learned counsel for the petitioner. Ms. D.D. Burman, learned additional senior government advocate for the respondent numbers. Respondent number 4, Ms. Sorry? B. Ms. B. Deka, learned standing counsel, elementary education department. For respondent numbers
1, 3, 5, 6, and 7.
1, 3, 5, 6, and 7. And Ms. R. M. Barwa, standing counsel finance. For respondent number 2. Stop. Having regard to the nature of case projected by the petitioner and the issue involved, the writ petition is taken up for disposal at this stage. Next para. Brief facts essential for disposal of this writ petition is that the petitioner joined service as a stipendiary teacher of Shernagar LP School on 26/2/1974, and her service was regularized with effect from 1/12/1974. Subsequently, she was confirmed in service on 3/8/1989 as assistant teacher. Consequently, the petitioner retired on 30/4/2017 as head teacher. Although the respondent number 6 submitted the pension papers and proposal along with all related documents to the respondent number 4 for finalization of regular pension and other pensionary benefits entitled to the petitioner, on scrutiny, it was detected that there was an excess drawal of rupees 3, 62, 248.
56 minutes.
I repeat, 362,248 on account of wrong fixation of pay. It is for this reason that the pension case of the petitioner could not be finalized. and aggrieved the petitioner is before this court. Stop, next para. The learned counsel for the petitioner submits that according to the respondent authorities, the pay of the petitioner was wrongly fixed at rupees 1685 instead of rupees 1555 as on 1/1/1989. And on an account of such wrong fixation, the excess withdrawal of pay had occurred. The learned counsel further submits that the excess withdrawal is not attributable to any misinterpretation or fraud on the part of the petitioner, and it was solely on account of some mistake committed by the authorities while fixing the pay of the petitioner. And therefore, in view of the apex court decision in State of Punjab and others versus Rafiq Masih, within bracket whitewasher and others, reported in 2015 for SCC 334, the excess amount drawn by the petitioner should not be recovered from him and should be waived for finalization of his pension and other benefits. Post of the learned counsel also submits that the Deputy Inspector of Schools, Dhubri, in his letter dated 11/8/2021, within bracket annexure I, had also clearly stated in his letter dated 11/8/2021, okay. After that, you add this. To the Director of Elementary Education, Assam, had clearly stated that the excess withdrawal was not attributed to any fault on the part of the petitioner. Stop. The learned counsel thus submits that the writ petition may be allowed as prayed for. Next para. Per contra, Ms. D.D. Burman, learned additional senior government advocate, has drawn the attention of this court to the notification dated 27/1/2022, within bracket annexure J, wherein it has been provided that the Pension and Public Grievance Department is empowered to waive recovery with a financial ceiling of rupees 1 lakh. And beyond rupees 1 lakh, the express approval of the Finance Department is to be obtained. Stop. However, it also provides that in terms of the Cabinet decision dated 28/10/2021, the Director of Pensions has been authorized to waive excess withdrawal up to rupees 3 lakhs in respect of provincialized school teachers and PRIs exclusively with the conditions summarized by the apex court in Rafiq Masi and others, Supra. Full stop. She submits that since the amount in the instant case is beyond rupees 3 lakhs, the approval of the finance department will have to be sought. Stop. Similar submissions have been made by Ms. R.M. Barwal, on a standing counsel finance department, and Ms. B. Deka, on a standing counsel, elementary education. Next, para, I have considered the submissions made by the learned counsels for the arrival parties and perused the materials available on record. Stop. The communication dated 11/8/2021, importantly cancel that, made by the Deputy Inspector of Schools, Dhubri, to the Director of Elementary Education, Assam, importantly indicates that cancel, importantly certifies that the excess dowry that has occasion is not attributable to any misrepresentation or fraud, etc., on the part of the petitioner. Stop. The apex court in Rafiq Masi, Whitewasher and others, Supra.
Case number 345.
Page number?
Case number 345, clarification.
Oh, that is the conclusion.
Yes.
Postulated as many as 5 situations under which the recovery of excess dowry would be impermissible. As can be seen from paragraph number 18 of the said judgment. Stop. Paragraph 18 within bracket small Roman 1 provides that it would not be permissible to make recoveries from employees belonging to class 3 and class 4 service for group C and group D service. Where payment has mistakenly been made by the employer in excess of their entitlement. To stop, as already noticed, the of schools, Dhubri, had clearly certified that the petitioner is not responsible for such wrong fixation of pay. To stop, the apex court decision also does not fix a ceiling for waiving such excess withdrawal. Stop. Under the circumstance, the decision of the apex court being squarely applicable to the petitioner, this court is of the considered view that the amount of rupees 326,248 said to be excess withdrawal will not be recoverable from the petitioner. Stop. It is ordered accordingly. Full stop. The respondents will, however, be at liberty to refix the pay of the petitioner. So as to calculate the entitlement of pension and other benefits of the petitioner. Such process be undertaken and completed as expeditious as possible and within the outer limit of 2 months from the date of receipt of a certified copy of this order. The petition accordingly stands disposed of as allowed.
Nice.
Yeah.
Who on Mary's lordship?
Merit, no reference.
Respondent also not filed the affidavit motion.
Yes, your lordship, we
Okay.
did not file a affidavit and also we have not received the instruction to file the affidavit.
Learned counsel for the petitioner submits that the matter may not be referred for mediation, having regard to the subject matter of the case. Stop. Ms. P. Das, learned standing counsel, Secondary Education Department, also submits that she is yet to receive instruction in the matter and therefore she may be given some more time to receive instructions. In view of above, matter stands adjourned for 3 weeks to enable the respondents receive the instructions to file their counter affidavit. This again after 3 weeks on a date to be fixed by the registry.
I'm deeply on this.
This lordship, there is a review petition. Other side is Dimasa's counsel for the Dimasa and council lordship. He has requested for fixed at 2 lordship. Will it be possible at 2? Otherwise, I am prepared it, because his presence is also required. Lordship,
It has to be heard.
yes, it is to be heard.
Any further pleadings have been directed?
No, pleadings is complete and they have admitted, our case lordship. Yes.
You are the petitioner.
I am the petitioner.
Your writ petition was dismissed.
Dismiss for holding that appointment was illegal. So salary, they are not entitled for salary because there was no advertisement.
Hmm.
But
Now why if
there is advertisement, lordship, but previous counsel, there is a misconception of fact. So it is filed on the basis of additional documents and subsequent events, which were, these are correspondence with the government for SIU approval. There was advertisement, there was interview, the interview committee was constituted, thereafter appointment was made. And thereafter it was according to the procedure, the NCL's council also approved it. There are 5 petitioners, 2 are graduate teacher and 1 grade 3, and 2 are assistant teachers.
why didn't you highlight all that in your writ petition then?
It is, that is the ground lordship, the mistake of council is also ground of,
Mistake of both councils.
no, I was not there, I was not.
Counsel for the writ petitioner was not properly instructed. And counsel for the respondent also was not properly.
Because there was no affidavit also, lordship. There was
No affidavit.
earlier. There was no affidavit. This is first time, as per the order of the court, they filed affidavit also.
Anyway, I think we'll post the matter after 2 weeks or something. There may be some difficulty today. We have some part matters fixed.
The date may be fixed for hearing.
The registry will fix the date. I'll say after 2 weeks, they'll fix a date. Okay. As paid for by the parties, let the matter be listed again after. Listed after 2 weeks on a date to be fixed by the registry. August. Yes.
Well, before my ground friend starts my, I submit my, the respondent 4 was directed to take some instruction. I have written, but the instruction is awaited. Some time may be allowed.
Respondent number 4.
Yes.
Who is that?
Principal.
Well, what is the matter regarding?
Family person.
Some similarly situated persons with given pension money. That informed.
You are for that respondent number 4.
Yeah.
You want some more time? How much
Instruction
time?
is awaited now. 10 days time.
10 days time.
A date.
I'm not giving dates, but I'll say 1 week or 2 weeks, whatever, they'll fix a date. Okay? Because I don't want to fix matters, too much matters in 1 day like that. We end up doing that. That's why. Mr. PJ Saiki, our learned counsel, they're paying for respondent number 4. Submits that he requires some more time to obtain instructions in terms of the last court's order dated 17/7/2025. Stop as paid for. Further 10 days time is granted to respondent number 4. To inform the court. No, okay, right, like this. Further 10 days time is granted to Mr. PJ Saike to obtain instructions. Registry to list the case again after two weeks on a date to be fixed by it.
Very well.
But here inspection is awaited, sometimes it's required, right? How we can. Huge may be granted.
They're taking time since not last 1 year, my lord.
You're dealing with one client, they're dealing with so many clients. This is the problem.
We have, my lord, annexed all documents, man.
And moreover, my lord, there are 2 petitioners from the Nagaon district and 1 petitioner from Dibrugarh district. From Nagaon district, the partial instruction has come, but from Dibrugarh, it has not come.
What is the matter regarding?
Regarding, my lord, the petitioners, my lord, they were selected, my lord,
Hmm.
along with other candidates.
As for
As for, my lord, postgraduate teacher,
PG teachers.
lordship.
Then
From the said list, my lord, who were, my lord, not appointed. By taking plea that some rate petition was pending. Then we approved this on court. This on court directed to appoint us along with other candidates. They did not, my lord. Similarly situated selected candidates, my lord, were appointed. After dismissal of that case, my lord, we were appointed in the year 2016 after 2 years. So we are, my lord, filing this petition, my lord, seeking, my lord, the area benefit as well as seniority, my lord.
area.
Lordship.
Okay. Appointment you have secured.
Lordship. The appointment has been given.
Okay,
But-
then you wait for some time. How much time should you require, Mr. Yu Sharma?
3 weeks, my
3 weeks time. Okay. Mr. Yu Sharma, learned standing counsel, secondary education department. Prays for 3 weeks time to obtain instruction of the matter.
Instruction and affidavit, my lord. So earlier there was order for affidavit. On 29/1.
This is second round or third round? Second round.
Regarding this benefit, first round. Second round, my lord. Otherwise, second round.
Mr. As paid for, further 3 weeks time is granted. Respondents shall also file their counter affidavit in the meantime.
My lord, may I pray, my lord, a date after 3 weeks.
The registry will fix a date. Registry to list the case again after 3 weeks on a date to be fixed by it. Yes. All right.
Let me please, your lordship, here we needed to file our detailed affidavit, which instruction is still awaited. Already communication has been made, your lordship, to Pokraja.
My lord, several times, lordship, they took time.
Your lordship, last occasion, your lordship, that thing, your lordship reflected that OM has not been annexed. So thereafter, your lordship, this is the first time, your lordship, already communication has made, your lordship, several times from our end, your lordship. So kindly accommodate your lordship.
My lord, your lordship will see, they have taken a stand in the affidavit that this OM is will not be applicable because the more than 5 years will be regularized. Now, lordship, according to the affidavit, lordship, they are saying that the matter is to be placed before the cabinet. Now they are taking that the matter, some instruction is sought from BPC, etc. Lordship. These are only, lordship, delay techniques. The person has been, lordship, retired in the year 2019. No gratuity has been, lordship, released in his favor. Earlier, several occasions, lordship, 11 or 12 days, lordship, I have that they have taken.
Last date too, last date.
That was unnecessary because OM is not a lordship relevant in this case. They are relevant
It was
is
honorable
relevant.
court direction, your lordship.
That is there. But
And
I
it's
also,
also there, your lordship, while passing the order.
no. I also raised that on that day, lordship, because that they are saying that simply saying that this OM is not applicable. I am not opposing on that. Their strength is the matter is to be placed before the cabinet.
Oh.
Let it be placed before the cabinet. Keep pushing, yes. In their affidavit, your lordship may kindly page 44. Para 7.
Page
The-
44.
Lordship, para 7.
Yes, your lordship.
They are
That
supposed to-
finance OM is needed to, your lordship, obtain as instruction and to file additional affidavit because that OM has not been annexed here. As per honorable court direction, I am placing the submission, your lordship. Not beyond that, your
Then why
lordship.
you are not placing?
Then your
Simply there, in fact, lordship, I am saying that OM is not applicable. They are saying, I am not opposing on that. They are stand in the affidavits that matter is to be placed before the cabinet. Place it. They are not placing, lordship. For last 6 months, 6 months, lordship, they are taking time in the name of placing the matter before the cabinet. Today they are taking a different term.
Then your lordship, as your lordship in our,
Affidavit is
in
clear.
our affidavit, your lordship, it is mentioned that as such, the department is requested to place the matter before the cabinet, your lordship. And
The
your lordship,
last two
we,
line.
we,
What is
we,
the last 2 line?
Mr. M. Khan,
Last one.
what is your prayer here for the pension?
More pension, gratuity, for
Gratuity.
releasing gratuity and for final pension.
Sorry, for final pension. You're receiving provisional now.
Provisional he is receiving.
You have not received gratuity.
Gratuity.
DCRG also not received.
Lordship, that is
Same thing.
same thing.
Gratuity and DCRG same. Then, and your regular pension.
Regular pension.
Why is it held up according to them?
My lord, they certain period lordship is required to be regularized. Lordship, I have stated in my paragraph.
You had gone for deputation.
My lord.
That period you had gone for deputation. That's why.
Yes, yes.
5 years. yes.
He was under deputation.
So that deputation period has to be regularized.
Regularized.
So
Only because of that, they are not.
there is no provision for that, for regularizing deputation period.
My lord.
What is your parent department?
Parent department was lordship education, that is adult education department.
Adult education, and you had
They-
gone for
they are-
deputation on to which department?
Lordship under SSA. Sarva Shiksha,
You
lordship.
had gone to SSA.
Yes. Because
From
adult
adult
education, lordship, that was old data.
So what seems to be the problem now?
Your lordship, the deponent has initiated process for placing the
Let me
same
say,
matter.
let me say.
Let him, I'm asking him. I'll ask you also.
Their problem is, lordship, they had submitted the proposal time to time for regularization before the government.
Regularization of that period.
Regularization of period.
Then
because Lordship initially he was deputed for 1 year.
Hmm.
From 2000, Lordship 3,
Hmm.
and he was there, Lordship, under deputation till 2009,
Hmm.
22/9/2009.
Okay, so,
And after that, Lordship, during this period, Lordship, the director of mission director, he has submitted proposal time to time that a person is required to be served in this department, in the SSS. So this period is required to be
oh, yes.
regularized. That
Then-
has not been done during the service period. Even after Lordship retirement, that period is Lordship is still in the whole Lordship. That has not been regularized. And because of that, Lordship, they are not releasing the gratuity. Big amount,
So-
Lordship is aware that.
So what do they say? They say that deputation is possible only for 5 years.
My lord.
You have stayed beyond 5 years.
Yeah, they are saying that there is an OM if the deputation period is 5 years, then the OM will cover it. And as the period is more than 5 years, matter is to be placed before the cabinet. That is the stand of the government.
Okay.
So they are taking time, Lordship, again and again in the name of placing the matter before the cabinet. In the affidavit also, Lordship, they have.
Are we
taken
allowed
time.
to obtain instruction pertaining to that, whether the process has been placed or not?
Definitely, I was trying to understand the case. That's all. Please understand that. So main problem is that cabinet has to look into this matter. And when will the cabinet sit? When are you going to place it?
They are taking time for last 6 months, Lordship, in the name of placing the matter before the cabinet.
They'll have to take time if the cabinet is not
They
sitting.
have to place it. The cabinet is, Lordship, sitting, your Lordship is aware that after 15 days, 1 month, cabinet is frequently sitting. Present status, whether it has been placed or not, that has not been placed. In the affidavit, Lordship, affidavit filed on Lordship 11/6/2020. Saying that matter will be placed. The process has already been adopted. Page 44, paragraph.
Anyway, yes, don't repeat again and again. See, Ms. P. Das, in terms of last court's order, you are supposed to place the OM,
Yes, your
isn't
lordship.
it?
Yes.
That you have not received.
Not received, your lordship.
How much time?
Only 1 week time. maybe.
1 week time.
Yes,
Sufficient?
yes.
Okay, as paid for by Ms. P. Das.
Doctor, may I submit on that? Lordship, in fact, Lordship, this OM is not relevant. The relevant is the matter is to be placed before the cabinet.
As paid for by Ms. P. Das, Learned Standing Council, the Limited Education Department. Further 1 week time is granted to place.
OM.
Present status, whether the matter is placed before the cabinet or not, that Lordship instruction may be.
To produce the Finance Department's observation. As stated in paragraph number 7 of the counter affidavit, along with office memorandums dated 19/7 to 1997 and 27/12/2016. Stop next para. The Learned Standing Council shall also obtain instructions as to when the matter of the concerning the petitioner will be placed before the state cabinet in terms of the observation made in the said paragraph number 7 of the counter affidavit. List again after a week on a date to be fixed by the registry. You obtained that status also, okay?
Then your lordship, status 2 weeks time may be granted, your
Why?
lordship, that cabinet instruction.
No, why 2 weeks now?
Today is Wednesday, your lordship,
So
so every Wednesday.
you'll come after 1 week. So then by the time you find out
Yes, sir.
when is the cabinet sitting, when they will place it, that much only we want to know.
Yes, sir.
Obliged.
Deeply obliged.
So what is the next item?
The UGC is to reply and the
Vice Chancellor Department are there to replace.
My senior counsel, Mr. Ken Chaudhary, is out of town, so any date may be given. He has finished his argument. I don't know. He concluded it. Yes, sir.
When is he coming back?
Day after tomorrow.
Day after
Yeah.
tomorrow. They'll be too late. He has already made his submission. Anything more to add? We have heard him. So who will submit now? UGC. Who's the UGC counsel?
Given our stance that papers which were submitted by the petitioner.
You come here.
Lordship,
Hmm.
UGC has already given a notification, a stance on the behalf of Pramod Medi, who has submitted his 10 papers. And it has said that the 10 papers are mostly presented on old journals. If you go to page number 30,
You have filed affidavit, is it?
counter affidavit. 128.
Page 128.
Para 11.
Just a minute, 128.
Counter affidavit, my lord.
In which case? 598 or
WPC 598 of 28.
598?
Yes.
UGC has filed affidavit.
Page 359.
The matter. When UGC, yes.
You said page 100 and
Counter affidavit,
100 number, 100?
350 at the starting page, 128.
That 128 part has been renumbered, okay? Now it's no longer 128, it's 363,
Yes, my lordship.
363. Paragraph 11,
Yes, my lordship.
yes.
Both the scholar, that is Dr. Pramod Medi and Dr. Pratibha Patwari, have submitted the list of their publications along with the names of their journals. The competent authority at UGC has gone through the list of the articles written by both the scholars and would like to place its comments, which are as follows. The list has been.
Just a minute, just a minute. Before that, when did the UGC come into picture? Originally, you were not a party, isn't it? Later on, you were impleaded. Now, has anybody, yes,
Lordship, sincere apology. Lordship, actually, the actual counsel for UGC, Mr. Somo, is not in court right now, Lordship.
Hmm.
He's stuck in a mediation.
Hmm.
That's why we've had to take up this thing.
it's okay. You can assist the court.
Lordship.
Affidavits are here.
Yes, Lordship.
See, my
Lordship.
question
Yes, sir.
is that UGC was not there originally.
Yes.
Later on, you were impleaded perhaps.
Yes.
And have you been asked by the court to give your opinion?
Lordship,
On what basis you are filing
the
this?
exact extent to which we have
Hmm.
been submitted to this particular affidavit is
Hmm.
to say only whether or not the journals
Hmm.
that the two people involved in this matter have submitted their articles to
Hmm.
are actually in the UGC care list, or they were previously in the other, previously recognized lists that were
Okay,
maintained by the UGC.
that
That is-
exercise you have done unilaterally.
Yes, Lord.
It's not that court has directed you or somebody has asked you.
Lordship, that was all, Lordship. We were asked for clarification on the status of the publication, Lordship. That is by this.
By whom?
By this court, Lordship.
By this court?
Yes,
Which, by which order?
Lordship, that I am not aware. I'll have to look through the records, honestly, but.
That is the allegation in the writ petition.
No, if it's by the order of this court, then you'll have to, you must have written somewhere in the affidavit. In terms of the court's order, this is what we have found.
Because of that. Our whole case is that.
Mr. Das, what I was asking is that who asked you your opinion? UGC was not the original party. Later on, they came.
The instance of the court, I think.
So that is why now, do we require that opinion of the UGC? To determine this case? If so, by which order? If not, what would be the thing? Because there's another opinion of the expert committee also. UGC committee opinion there, expert committee opinion is there, and one side, the original selection committee also is there. So, all these people are experts. Now, who will be the person who we say that this is the correct thing?
What, may I just, well, UGC was made party, I think at the, I'm trying to find out. Because we submitted that, you will have to check the order.
No, correct. See,
Yes.
at paragraph 1 of their affidavit itself, they have explained
Yes.
that we have been impleted as a party. Okay,
Yes,
fine.
We implemented
Any
party.
particular, okay, fine.
UGC is expert only in regard to their paper, not their UGC care. UGC care list. They say that we are not expert in saying what is that peer reviewed. Peer reviewed paper or not, they are not expert. So they have commented only on UGC care list. So they have said, my lord, respondent number 8 has got only one paper UGC care listed, and for petitioner only 5. As regard my lord peer listed, they are not commenting.
They have no comments.
They are not commenting. So I am not saying that, my lord, but the authority, my lord, what my case is, my lord, your lordship may forget UGC also. My lord, it's not relevant for the timing in a sense, because they are saying that for peer listed or not, we are not going to comment. We have no authority to comment. That's what they say. So therefore, UGC and peer listed, my lord, paper. So this has been already, my lord, that expert committee has been formed by the appellate authority. Director Higher Education is the appellate authority where we have filed our complaint. So on the basis of that, my lord, expert committee has given a report, and that expert committee's report has not been challenged by anybody. So therefore, what my suggestion and submission would be, my lord, before your lordship, taking into consideration the whole gamut, my lord, the expert committee or the Director of Higher Education can hear both sides and come to a conclusion as regard whatever they want to say. Or because this expert committee report has remained unchallenged, your lordship can also take a decision on the matter. But in the facts and circumstances of the case, I think it would be appropriate on your part, on the part of this honorable court, that all right, the appellate authority Director Higher Education is there. I have given my lord, he should hear both parties and take a decision, or at least the affected party.
Appellate authority means under what provision of law? Appellate authority.
He is the appellate authority. The Director Higher Education
And
is the.
has anyone gone to the appellate authority?
Yes, yes.
Who has gone?
Petitioner has filed a
So
representation.
there are 2 petitioners. Which one?
In the.
Who is
second
holding the post now? Your client is holding the post.
My client is holding the.
He is holding the post.
Yes.
Okay.
I've stated, my lord, that a person who has been placed at serial number 1, she doesn't meet the qualification prescribed as per the advertisement and prescribed as per the UGC regulation.
You had filed a subsequent writ petition.
Subsequently.
The earlier one writ petition was filed on the ground that I'm number 1 and number 2 has been appointed.
Number 2 has been appointed, and.
Then when the matter is pending, you file say that number 1 is not qualified.
Not
Number 2 is qualified.
Yes, number 1 is.
Now that expert committee has been formed.
Formed.
Is it in terms of the court's direction or
No,
they have
no,
on their own
because-
form?
Because our representation is there, where we have said that the petitioner number 1 is not qualified because of this, that. So therefore, on the basis of in order to file the affidavit, in order to bring the correct fact before the court, I think it is the duty on the part of the authority to form a committee to find out who is, what is what.
So the committee is formed.
Committee is formed and committee has given a report. The director and this.
And the committee has been formed on the basis of representation
Filed by us.
filed by you.
Yes,
Other side also.
other side's paper has been also checked.
Okay.
My side
Where is that representation?
representation is at serial.
And representation and the community,
113, man.
113,
Yes.
113.
And my whole read petition is that. So in order to come to a conclusion, they cannot do it on their own. Director higher education doesn't have the expertise.
Prabodh Medhi is the person who is currently functioning.
And
Okay.
because they are saying that he is in Bodoland and he knows Bodoland, therefore in terms of the advertisement, the preference will be given to the person who resides in Bodoland. That may not be legally correct also, that I agree.
You're not
But-
confident about that.
No, your lordship is confident, I am happy about it. But- So I am.
So you come up with the qualification partner.
Because I am backed by 4 judgments of the
Okay.
Honorable Supreme
Okay,
Court.
this is your representation and
Yes.
pursuant to this, where is that committee?
Committee has Director Higher Education, page 394, I think.
394.
BTC could go again.
It is annexed by one of the respondents
Yes, I think the BTC has filed an
Or-
affidavit.
or you're relying upon that
That your lordship will get it at BTC, my lord, page,
BTC's affidavit.
yes, it starts from page 388.
394, is it?
Yes,
Minutes of the meeting of committee constituted for
your
re-verification.
lordship will read paragraph 12.
Paragraph 12 of the
Yes.
BTC affidavit.
Yes, not BTC affidavit, yes.
Hmm.
May I read, man?
It's okay, I've read it.
Yeah.
4424.
391, page 391.
4424 is the notification and constitution of the meeting is 1624.
Yes,
And annexure
one,
1 collectively is the minutes,
yes,
correct?
yes. And your
Now-
lordship wanted to know who are the members, one notification was there, that notification
Ah.
was placed before your lordship.
Now, what has happened to these minutes? It remains as a minutes only,
It
isn't it?
remains as a minutes because.
Well, matter is sub judice.
Sub judice.
Sub judice.
So what?
So what you're saying is that on the basis of this,
They can hear both
uh,
sides and decide some.
on the basis of the constituted meeting, committee, findings or whatever, both sides be heard and let the director take a decision.
Yes.
Now,
That's-
this is,
My lord, see, one factor I'm saying, my lord, since the committee report has not been challenged, your lordship may take it as it is. Otherwise, my lord, I think it would be appropriate if the director is directed to decide upon the matter after hearing the affected party.
no, that's
That would
true.
be better.
Now, you have to show me where is the provision
Yes.
that director is the appellate authority in
Yes,
such
that-
kind of dispute.
In science matter, my lord, always director is the higher education. Director higher education.
But this is a director of education BTC,
BTC. So they.
not the
BTS
state, BTC.
BTC. So normally higher education matter. Here, let me- Is it right? Is the. It is not the governing body. Whenever the selection is done, my lord, by a governing body, matter goes to the director of higher education. and the director has to either approve or they do not approve. Or they entertain, my lord, any.
That has happened here also.
My lord,
Even here also,
here also.
the selection committee sat,
Yes,
made the recommendation. It was placed,
Appointed by-
it was placed before the managing committee.
yes,
Managing committee then
Not managing-
forwarded.
forwarded, yes,
Governing body.
yes,
Governing body forwarded to the director.
yes.
And director has approved your name.
Respondent number two.
Hmm.
Well,
So that is the process.
So that is.
But insofar as appeal is concerned,
He is the person who looks into this thing, my lord. What is it? Made by the director on the basis of the recommendation given.
but Mr. Das, you have been appointed.
Yes.
You have been appointed. Why should you file an appeal?
No, no. I filed an appeal because my petition, which has been filed by the respondent number 8, my lord. There are some, supposing if I lose there, and there is possibility because my lord, your lordship has seen Supreme Court judgment and all. And otherwise, my lord, I find, my lord, after checking on the basis of the RTA application, the research paper which has been obtained by the petitioner, my lord, he has found out that the research paper is not in tune with the terms of the advertisement and the terms of the UGC regulation. So if I lose there, my lord, I lose. If I gain there, my lord, I gain. Only, and I have annexed these three, my lord, writ petition, three, my lord, judgments of the apex court and the division bench of this court, where the court has interfered when the selection process itself was in violation of the UGC regulation. Court itself, my lord, they found that the committee which has been, my lord, may I just point, I have made a small, my lord, written submission. If your lordship would like to see, I can point out.
So you were fired with guns. Now you have retaliated with your writ petition. And one more representation you have sent to the director
Director, yeah.
to say that, see, I have been challenged, but look at him. He does not have that qualification.
Absolutely. Your lordship
This is
has
what
put
he
it
say.
there.
Now, Mr. Bora, who is for the BTC, will help us. What is the provision for appeal? Any provision?
I'm checking it. I have not been able to find it out. My handicap is that this particular case is looked by SR Rabha. He is out of station.
Rabha.
That's the difficult another.
It is always the director, man.
No, in principle, I mean,
Yeah,
generally, I think all the arguments, whatever has been made already. Now, I just want to know that provision, that's all. If there's any
Specifically, it is not
any
there.
provision
It's there
or-
appointments either. But
Oh.
if when the matter, normally, when the matter regarding the selection goes after the governing body, goes to the director, the director looks into it. And if somebody, always, it happens, if the matter goes to the director, one party goes and files a complaint there, saying the selection is bad because governing body has not followed the regulation, or the person who has been selected is not qualified. So we always go, we come and file appeal writ petition before this court.
Now, what about the secretary? Does he have any role?
Secretary doesn't have it.
It does not reach the secretary level.
It doesn't. My lord, if your lordship wants, my lord, what my submission in total is that, my lord, anybody can look into the research papers for the purpose of scrutiny. I'm not saying that the expert committee may be wrong or right. But whatever the expert committee is, the constitution is very high body. My lord, it's a high body.
Mr. Das,
Well-
there are so many possibilities. I have not made up my mind whether it should go that way or that way. That we'll have to see in the due course. But now I just want to know what are the probabilities,
Yes,
like court itself decides on merit
yes.
or refer it, ask the party to, the respondent appellate authority concerned to look into the matter, giving the opportunity to the parties and taking a call.
That is second, my lord.
That is the second thing. So, see, there are options. So that's why before, supposing I want to go for that option, I want to know precisely what is the provision.
My lord, I can
Because
give
later on
judgment.
in the long
I
run,
can-
people will come, this matter also has been referred to the director, this also should be referred.
I think I can show judgment where the director decides.
Fine.
BTC area, the law is slightly different.
BTC is that, this is the transport subject. So
Ah.
there is the director for education, they include software.
Ah.
This is the transport subject to BTC.
So this may not be the first case. There must be other disputes also, wherein the
Lordship,
director plays a role.
Your lordship may kindly see this, my learned friend has pointed out.
What is that?
May I just read it?
Yes.
Assam Education Department Rules and Orders. Rule 307(2) of the Assam Executive Manual provides a framework for appeals within the Education Department, potentially including the Director of Education's role as an appellate authority.
Please repeat the rules. Is it available in any books that we have here?
Should be the department, executive manual should be there. Assam Executive Manual will be there.
Education manual is here, then we have services manual, then
And so many decisions are there. I can provide at 2 o'clock your lordship.
Ah.
2 o'clock. We'll try to find out, work hard.
yes, yes.
1 or 2 decisions, there will be there and.
No, decision is there, no doubt, but I just want to know the provision, precise provision, if there's any provision for appeal.
Statutory provision of something like that.
Sorry?
Statutory provision, then it will be.
BTC you can provide from their own end, whatever they have. Because BTC's things are normally director also, they are only director decides.
Mr. Das, you were also with the BTC for a long time.
No, I was not in the BTC.
You were
I
not
was
in,
Tarvi along.
oh, you're in KSE, okay. They must be having similar provision.
But normally, they follow whatever is followed by the government of Assam. Normally, this is what they do.
Okay. Please find out the provision and tell me under what provision.
That's been taking about 2 minutes.
That
Yes,
should be done.
we'll have to take it up at two.
Or any other day, madam, because Mr. Radha was attending that particular case.
No other day, there's a problem, you
Yes, sir.
see. Tomorrow I've got one other part hard,
No.
and this court is available only till Thursday. Otherwise, I would have taken that Aram say.
No.
Because next 2 weeks I may not be here.
When is your lordship sitting next one?
I'll be sitting only next month,
Next
Yeah.
one when?
perhaps beginning of the month.
Let it be there on first, we'll all prepare and come back. Mr.
That cannot be done.
Your lordship has already heard the matter and I am going to provide a written submissions.
Problem is that I'll forget the matter then.
We'll remind your lordship.
By that time, I'll forget everything, then you'll have to again argue from the beginning. We'll have it at 2. Just see the provision,
Yes,
what
yes,
is there for appeal and all that.
Yes,
And what I want to clear the mind is, court has not directed anybody, isn't it?
Court
That you
has not-
form a committee, give your opinion and get back to the court. It was, in fact, on your representation that the BTC had acted upon it and formed a committee
Yes,
to look into it.
Because my BPC, my lord, all research papers were submitted before them. So they have no option in order to file the affidavit for the purpose of commenting on the research paper. They will have to say it on their own. So they have not done it on their own because they are not expert. So they have formed a committee and on the basis of the committee, they file the affidavit. They have no other option because my whole writ petition is about the research paper on whether it meets the requirement of UGC and peer, that peer listed or UGC care listed. This is the only thing I have.
When
The whole writ petition is that.
and the committee has given all the, taken consideration of all the research papers.
And they are expert committee member. It is.
Okay, so you filed this representation, then what about the petition and the other case? Has he also filed representation?
No, he did not. His only case is that I am number 1, so I should be able.
Give me the other one.
But they have not challenged that the UGC regulation. Well, your lordship will kindly see that advertisement. There are some people also there.
No representation.
No, they have not filed. And they have not challenged the terms of the advertisement also.
No, just a minute. I think there's one. Do you have a copy of the writ petition?
Their writ petition.
Yes. Annexure G seems to be a representation to the secretary, BTC. Application to reconsider approval of recently posted regular principal of Goreshwar College.
Page 28, Your Lordship.
Correct, 28. And 29 is the type copy over. Or same thing. No, this is to the director.
To the director.
Normally, all things are looked after by director, even in respect of ME school, LP school, director. After the order, my lord, of the director, maybe they can go to secretary. And in their writ petition, only my argument that advertisement, if your lordship comes to page 24,
Yes.
serial number 10. Preference shall be given to the candidates belonging to the BTR. BTR means one has to be a resident of that area, must know Bodo language and all those things, which the present petitioner, in the other case, he has. And they have not challenged this.
In order to make such selection, what is the procedure? What rules are adopted?
Procedure is that one has to meet the UGC regulations.
No, any particular rules you have?
No, the terms of the advertisement.
like in the
UGC
state-
regulation.
Like in the state, you have the rules in BTC area.
Can you see the regulation? I have annexed it at page 59.
Of your writ petition.
Yes. Particularly, it will let us. Particularly regulation 73. Page 73, sorry.
70. What is the composition of the selection committee?
Selection
Page
committee,
24, my lord, of the petition. 3543. Page 24. There are together 7%.
No, that is the, what we call a mark sheet.
Mark sheet, there the composition are down below all these things, 7 signatures are there. my lord.
No, what I want to know is what is the formula? From where, under what rules? That the director, chairman, members, so and so has been prescribed. Qualification required has been prescribed by the UGC norms 2018.
yes, page 73,
Uh,
and also,
that I've seen.
yes, and also
But-
the advertisement.
The composition of the meeting, DPC itself, nothing like that.
Governing body, madam.
This is a provincialized college.
Yes. Madam, and also the advertisement.
No, advertisement will be
Yes,
there,
yes,
but
yes.
what is the beginning, genesis?
Yes.
Some colleges employs provincialization rules.
Lordship, Lordship comes to page number 99.
No, please come to
490.
page 54. The impugn order. They also rely upon the Assam College Employees Provincialization Rules 2010,
Yes, that's
Rule 7A.
7.
Let us see that rule.
Page number that. First we know the manual minor.
Manual, yes.
Manual, page number 498. And the composition will be in the section 7, the same committee. 499.
498,
499.
499.
499.
Rule,
Rule 10 is the total number of committee of department.
Rule 10.
Rule 10.
So in this rule itself, there must be a rule for appeal.
Section 15 is there. This is all employees of the Assam Province. They say appeal and discipline appeal. 15 maybe. 501 page
15.
15. This is regarding discipline and appeal.
This will be after you are employed.
Yes.
Supposing you are not employed, you are only a participant.
Not by kindly see this. Yeah. Next page, amendment to rule 3. Below me.
Assam College Employees Provincialization Amendment Rules. Principal rules is 2010.
Yes. Amendment is there 2007.
This is 2017.
Whether this is followed or not, that will give me.
You are referring to which rule?
Well, last year, Lord School, amendment of rule 10.
Rule 10.
Yes.
In the principal rule 10, rule 10, existing A, B, C shall be renumbered respectively as clauses B, C, D. And the following new, inserted.
Follow his.
The original ABC
Yes,
will give way, will be renumbered as BCD.
yes.
And instead of the original A, this is the provision. There shall be a selection committee for selection of posts of principals by direct recruitment in the various provincialized colleges. Selection committee shall consist of the following: Vice Chancellor,
He was not there.
not there,
President
of the affiliate university, President of the governing body.
Yes, Vice Chancellor is there, madam. Vice Chancellor Woodland University, Chairman.
He was there.
Yes. Page number 24.
24. Mark sheet
24 of
of the previous writ petition.
petition number 3543.
Vice Chancellor is there, Bora University. Then President governing body is there. One nominee of the governing body and the Vice Chancellor.
There are
Three experts.
2 experts is there.
It was like a 3 expert.
3 experts.
Academy shall not below the rank of professor. At any rate, the composition is not under challenge.
I'm not saying because
This will give me, if there is anything wrong, my lord, this will give me additional points. But I am not going there, my lord. Since my selection is also there by the
Correct.
same committee.
Both are the selected,
Both
and
are-
one says that being number one, I should be appointed. The other says that no, I've been appointed, although I'm number two, I've been appointed because I'm a local. And secondly, number one, those papers, whatever he had submitted.
We are saying that in the other petition that you are not qualified. Number one is not qualified, please look into it. So they have formed an expert committee and committee has given the result. And that has not been challenged by the respondent number 8. Director is the contingency.
So this provincialization rules is followed by the BTC also.
Yes, so therefore director comes in.
Now, in regards to the appeal, what would be the provision?
Not appeal, regard to any malad complaint regarding the selection procedure, it is the director who looks into. Therefore,
Director gives the final say regarding the recommendation made,
yes,
then appointment is made.
yes.
But
And he
if-
also looks into malad any allegations as regard the candidature. Or the procedure adopted by the governing body.
But there should be some provision, some written provision for that.
That manual, that Assam government manual provided me. That is there and some case laws will be there where the director decides everything. My lord, Boroland Territorial Council, there is a website, my lord, may I just read? The education department is the transfer subject to the BTC and is the nodal department for proper administration and maintenance of educational sector under the BTR administrative area. The Office of the Director Education BTC being the council head of the department is the overall authority for academic and management of the entire education department of BTR. All the sectors of the education department under BTR are looked after by the Director of Education, BTC, from elementary to higher college level of education, including Sanskrit tolls and madrasas, except the technical educations and university. The BTC Secretariat, along with executive member, Education Department, BTR, is the administrative head of the department, take policy direction for the entire Department of Education for implementation. So this is from the website of the BTR.
Education is a transport secretary. And director is the main person there.
Main person.
That's the name of it.
Can you find out the method of recruitment of the hide lottery? With rules and fine.
That is the Assam.
Government body. Until the director has to.
No, surely that is.
What where, so the transfer subject of BTC. And it is director of the BTC, then.
No, that is what has happened in this case also.
No,
Selection committee made the recommendation, put it before the governing body. Governing body then send it to the director. Then director has appointed one of them. Approved. But now when it comes to some discrepancy and some complaint, whether it will be the same director who will again listen to them.
But the director is not a lover.
Your lordship may provide that, say, let secretary hear the matter. I have no problem. Or anybody.
No, but there has to be a basis, you see.
No, so that if director passes an order after hearing all sides, my lord, then an appeal can be, a secretary can hear the matter. Normal trend, my lord. If they can, secretary education can hear the matter on the basis of the, whatever the order passes by the director. Now, this expert committee, my lord, if your lordships takes into consideration expert committee, and if your lordship takes into consideration that it has not been challenged, your lordship can take a call. Otherwise, if the matter goes to the, your lordship may direct the director that you hear the matter and decide, after hearing both sides, you decide the matter. That is another aspect of the matter. And if he comes to a final conclusion on the basis that this person who has applied did not have the qualification, then in that case, my lord, he can challenge that order by filing appeal before the secretary, by coming to the High Court again. Because the basis has to be there, because this expert committee, that basis is there. Even the UGC affidavit, out of 10, my lord, because initially the present petitioner, my lord, he has annexed 10 of his research paper, and he has annexed 10 of the research paper of the respondent number 8. Subsequently, by additional affidavit, he has filed another 10 research paper, because he has submitted in total 20 research paper before the authority. This they accepted in their affidavit. So out of 10, my lord, the UGC said 5, okay, UGC care listed, and for them 1 is UGC care listed. And regarding peer listed and all, we don't have any authority to comment upon. So therefore, the matter, the director, I think director has done the right thing by appointing an expert committee, because he is not an expert. He has to appoint an expert committee to comment upon it.
So how will he decide now, the director also?
Yes,
How will he decide?
he will hear both sides. He will hear.
No, he
the
himself has
petitioner.
appointed, he himself has, like you said,
He has
he has appointed an expert committee.
Yeah, he will seek an comment from them, comment from the petitioner in the other case, that what do you have to say on this? Comment on that, then he will declare the results. That an unqualified person was called for and his interview was taken. This is, my lord, the judgments in, I have annexed in the 3 of the judgments, where, my lord, the selection committee, my lord, appoints a vice chancellor who doesn't meet the requirement of qualification. Court says he doesn't meet the requirement of qualification. Then selection committee, my lord, instead of 3 experts, 2 experts decides. The court says no. Since the committee has been formed wrongly, so the selection process itself is wrong. So there I have a next one judgment, Baneshwar Gogoi, that was selected by the APSC, that was set aside by this court. On the ground, the expert committee is not as per the regulation. So these kind of things are there before the court also. And director, it is the director, my lord, who takes a call on the matter. May I give my written submission if your lordship pleases, my lord, I can. It is small, but because I have annexed the copy of the judgment, so it looks bulky. Otherwise, it is this much. 4 or 5 pages. Submission, my lord, all the affidavits.
No, if we go to that, if we take resort to that suggestion which you have made, I don't think we have to go in a detailed discussion of
Nothing.
anything.
No, I'm
We need
just
not- we
placing
need
it
not
for
go in-
lordship's not convenience. So that what is the affidavit, what is the reply, all these things. Then I have annexed a copy of the judgments, all because where the selections are, have been interfered by the.
What is the judgment you are relying upon the other day? Some judgment?
My lord, I have given a gist of the judgments. The lordship may kindly look into it. I think. Very good.
No, somebody had supplied judgment the other day. Was it you?
I have given, Mr. Chaudhary has also given, saying that the selection on the basis of the preference belonging to the BTC is not good. He may be correct in that thing, but he has not challenged the terms in the advertisement, which says the preference will be, here both are qualified. So therefore, the BTC has selected the persons who belongs to the BTC. Belongs to the BTC member means, that means he knows Bodo language. He knows Bodo language. That is what their affidavit also says. And their affidavit also says that he is from BTC and he knows the Bodo language.
One is that Audam Rajan Singh citation which you have given me.
Huh?
2015 SCC online.
SCC online given by me, my lord.
Yes, given by you.
Yes. My lord, may I just place this, my lord?
Let's see. Let's see such guidance.
My lord, gist of the judgments I have given your lordship may not take so much, my lord. Your lordship. A, B, C, D. Requirement of evidence of published work and research guidance with the 3 selected and recommended candidates for the post of principal did not have. So that was interfered with.
See, only problem is that you see whether they have followed the UGC guidelines or not. This will require some expert.
That is another aspect of the matter.
For the
Then the whole
court
selection will.
to determine that this is not correct, that should have done that will be quite difficult.
No, I'm saying that because my lord guidelines, terms and conditions of the advertisement says so, that you are required to have that 10 research paper.
Exactly.
Yes.
Whether that 10 research paper is acceptable or not, this is one thing which can be determined only by experts.
Experts, yes. That is,
And the expert is like the selection committee.
no, selection committee, my lord, selection committee has.
They were authorized to look into it.
No, they have done it, but they have done it wrongly, and this is what they have found. The expert committee constituted by the director has found out that the selection committee, my lord, that they are, my lord. They always do this kind of things, my lord. This is very easy, that 10 research paper I give, or 10 research, okay, 10 research paper are there, so we have done. This is this committee, they are not, I mean, they do not look into that.
They're not expert enough.
No, expert enough, they make mistakes.
You see the composition, we have just seen the composition.
Yeah, no, but.
Vice Chancellor is there. Then
No, they form a committee.
Nominee of the governing body president and of the Vice Chancellor. 3 expert
That is for the
members.
purpose of selection and also looking into the papers. But when they make mistake, my lord, it has to be looked into by somebody. They may make mistake. It is not be and all and all, my lord. Whatever they make, it will be the final. It cannot be like that. So when they make mistake, we find out. What your lordship is saying that, my lord, yes, they're expert, but this expert can make mistake. So therefore, the provisions for filing appeal before the director of the higher education.
Your citations are basically appointments being made in violation of the guidelines. Because you stick to that 10 papers,
My lord, yes.
condition of the advertisement, in the
Yes.
advertisement.
That is the UGC guidelines also. That is terms and conditions in the advertisement. That is at page 73 of the writ petition. Your lordship will kindly see page 60. Page 60 of the writ petition and 73.
Minimum 10 research publications.
Yes.
In peer reviewed or UGC listed.
Peer
journals.
reviewed or UGC reviewed, that has to be looked into, my lord. In
That-
any cases, looked into by the committee, and if the committee makes mistake, it has to be looked into by the director. So here we have pointed out that the committee who have selected,
Director is not the expert again. Na?
no, director, he, therefore he has committed, constituted committee. Man.
So the committee has recommended in whose favor?
The committee has said this much only, that the research paper submitted by the petitioner
So
18
the
is
director also will be bounded by the observation made by the committee,
expert committee, yes.
expert committee. So if expert
therefore-
committee has given some opinion against
So therefore,
either of the petitioner,
yeah,
that is how the matter will end.
yeah, that's what I'm saying, my lord, your lordship may take a call on the matter on the basis of the unchallenged expert committee report, or your lordship may direct the director to hear the respondent number 8 and then decide.
Director on his own has confirmed the committee, isn't it?
On his own, on the basis of the representation submitted by the petitioner, and also on the basis of the writ petition, because the writ petition is all about the research paper. Sometime, my lord, we find, my lord, there are case laws, my lord, where PhD is requirement of the UGC. The PhD are, the selection committee selects a PhD holder. But later on it is found he is not that PhD which the UGC requires. He must have passed from some university which is not recognized by the government. So those kind of cases are also there before the court.
Is there any rejoinder filed to the affidavit of the director by anyone?
Nobody has filed, I think. Not, it remains unchallenged.
One is silent on it.
Yes. So therefore, my lord, your lordship can take it. If it is unchallenged, my lord, it is a fact. So that day, my lord, the first day argument, they filed an affidavit saying that this is arbitrary. They filed an affidavit because your lordship has allowed. You have not done anything on the basis of the affidavit filed by the director. Your lordship may kindly recall. Then Mr. Chaudhary said, we'll file a small reply. Your lordship may look into it. My argument is complete. That reply is there. That affidavit has been filed.
What do they say in the affidavit?
They say it is arbitrary.
The expert committee,
No, they say,
which is arbitrary.
okay. That is. Yes, on that. Page 421. Para 4.
Paragraph 4, isn't it?
Yes,
They have said that yes, it is
constituted arbitrarily.
arbitrary and illegal manner. But this is in a reply.
On the first day of the argument. But your lordship will decide.
We'll come back in the 2. Let's see what you can do about it.
Committee complicated. The director's part, it is obvious,
Lordship, we have reservations regarding the director's part, Lordship. Lordship, in our affidavit in reply, we have.
You're for?
I'm for the respondent number 8 in item number 19 and for the petitioner in item number 20, Lordship. In fact, the authenticity or the validity, the legal, when we are questioning the validity of the expert committee, which was constituted arbitrarily, Lordship, the director has no say in constituting, that the director cannot constitute that committee, Lordship. Because if a committee, expert committee is to be constituted, Lordship, it has to take into consideration the UGC guidelines. And Lordship, the committee has to be constituted by the Borderland University. The director, Lordship, they are basically for administrative purposes. They look into the administrative integrities, Lordship. And we, in fact, in our affidavit in reply, Lordship, we have categorically stated our reservations, Lordship. Lordship, on a if I sum up the arguments, Lordship, the first issue in our hand is this: that in the first writ petition, we are challenging it on the basis that the respondent he was selected only because he had the preference that he was a local resident of BTC area, Lordship. In that case, Lordship, we have already submitted a judgment before your Lordship on the day when my senior argued. There is a judgment called Madhav Sutradhar versus the state of Assam. Lordship, there has been categorically, from this honorable court, it has been categorically stated that preference can be given only when both the candidates are on the equal footing. And here, Lordship, the petitioner in the petitioner in the item number 20, she was way ahead. Lordship, she was selected by the selection committee on the basis of her merit, and yet that clause, the director himself, he used that clause arbitrarily, Lordship, only because on the strength that he is a local resident. But that should not be done, Lordship. To that effect, Lordship, that Madhav Sutradhar is there. It has been squarely covered, Lordship, and it has been held that when preference should be taken into account. And Lordship, coming back to the Lordship has found.
Yes, carry on.
Lordship. And coming back to the item number 19, where we are respondent number 8, where they are challenging our our qualification criteria on the basis of this on the journals. For a moment, Lordship, I want to take you to the advertisement. What has been stated in the advertisement? What was the criteria in the advertisement, Lordship? Lordship, in the repetition of the Lordship will find the advertisement at page number 22 of repetition number 3543 of 2023. Let us see what is there in the advertisement, Lordship. Lordship has found it.
Yes, this.
Lordship, Lordship, may kindly see point number 5, Lordship, of the advertisement. Lordship has found it.
Read what is
Yes,
there?
Lordship. A minimum of 10 research publication in peer-reviewed or UGC listed journals and a minimum of 110 research score as per appendix number so and so at table number 2. Lordship, to my in my humble submission, Lordship, specifically they have used the word or. So, Lordship, we should not go into that debate, Lordship, that whether UGC care listed it was if we at all go into that debate. In the first instance, Lordship, we should not go into that debate because we are duly qualified, because all the research articles that has been submitted by us are all peer reviewed, which my learned senior on the previous date has already showed it to your Lordship. And Lordship, regarding the UGC care list, Lordship, which they are raising, we are saying that we qualify that criteria. Now, in order to negate that, they have the director BTC, they have formed a committee. Now, Lordship, as I have already stated that the committee, there is a question mark regarding the authenticity of the validity of that committee, Lordship, because on what basis, under what provisions they have constituted committee, Lordship, arbitrarily. And if we see the constitution of the committee itself, there also we can find anomalies. Lordship may see my affidavit in reply. We have raised the question. The members who have been selected as the members of that particular committee, some of the members were the persons who have called me for the interview in the first instance. So they are also a party here. Lordship may kindly see my affidavit in reply, Lordship.
Paragraph.
Paragraph number, Lordship, 5, Lordship. May I read, Lordship?
Yes. Read.
That the deponent begs to state that a serious question as to the validity of the committee constituted on 4/4/2024 comes under the scanner, as because the said committee has no legal validity to undertake such an exercise, as because most of the members of the said committee were involved and instrumental in the illegal appointment of the writ petitioner to the post of principal Goreshwar College. As a matter of fact, the chairman of the re-verification committee, Amarjyoti Burman, have had himself recommended Jagadish Brahma to appoint the writ petitioner as the principal of the Goreshwar College, superseding the rightful claim of the respondent number 8 before filing of the writ petition. Now, Lordship, the most important part. Thereafter, another member, Lordship.
Just a minute. Who is this Jagadish Brahma?
Lordship, he was the chairman of this re-verification committee, Lordship. And he had appointed the petitioner as the principal of the Goreshwar College even before the formation of that re-verification committee. Later part also.
No. Chairman of re-verification committee, Amarjyoti Burman, had himself recommended Jagdish Burma to appoint the writ petitioner.
Lordship, thereafter, Lordship.
Somebody has recommended somebody to appoint somebody like that.
No, he was the appointing authority, Lordship.
Who is?
Yes, he had recommended, Lordship. Yes, he had recommended.
The chairman is Amarjyoti Burman.
Amarjyoti Brahma.
Brahma. He said Burman here.
Burman, sorry, Lordship, Burman.
He has recommended who? Jagdish Brahma.
Jagadish Brahma to
recommend the
writ petitioner. And later part, Lordship.
Double recommendation.
And not only this, Lordship, the most important part, Lordship, thereafter another member of the re-verification committee, Dr. Manjil Bosumatari, who also happens to be the academic registrar of the Borderland University, was the same person who had earlier called the deponent, that is the respondent number 8, to participate in the interview. So, Lordship, he was the person who had checked all the qualification criteria of the respondent number 8 and had called her to participate in the interview. If I was not at all, I was qualified, I should not have been called in the interview in the first instance itself, Lordship. And interestingly, becomes a member of the re-verification committee only to negate the validity of the research papers of the deponent. My first argument is this, Lordship, that we should not enter into this argument when specifically and categorically in the advertisement itself it is written that peer-reviewed or UGC care listed should be there even. And since we have already qualified that criteria by submitting all my research articles where all the research articles are peer-reviewed, Lordship, the argument of the respondents does not find any place, Lordship. And Lordship has very much correctly raised this question that from on what basis they have constituted this committee, under what provision. to my limited understanding, Lordship, there is no such provision to constitute such a committee. It's a whimsical committee, Lordship. They have formed it on their own only to negate the rightful claim of the writ petitioner in item number 20, Lordship.
No, just coming back to the statement at paragraph 5,
Lordship.
chairman of the verification committee is, of course, Amar Jyoti Barman.
Brahma.
Amar Jyoti Barman. Then the second name is Jagdish Brahma. Where does he figure?
Jagdish Brahma, Lordship, he's a part and parcel of Lordship. Lordship, may give me 1 minute.
Jagdish Brahma happens to be the director of.
Director of-
Education. Amar Brahman happens to be the chairman as well as the secretary to the BTC Education.
Amar Jyoti,
He's the chairman, he also holds the.
Happens to be the-
secretary
and
of the BTC.
secretary
He is
BTC.
the CS officer, he is the secretary of the BTC looking after it.
Okay, and the Jagdish Brahma is the,
Happens to be the director of the.
he's the director.
BTC.
He's the director.
Direct.
He has appointed,
Okay. So there's a remote control behind the director.
Lordship, in my humble understanding, this is the case, Lordship.
Okay, then,
So Lordship, instead of going into that debate, if we see the fundamental aspects, Lordship, if we see the advertisement, then also I am eligible. And Lordship, the basic purpose of filing this writ petition in item number 19 was to counterblast my claim, Lordship. Because since I was selected on the basis of my merit and arbitrarily my merit was negated only on the fact that the second merit listed selected person happens to be a person from BTC area and arbitrarily the preference clause was used. But when preference clause should be used, it is already there, Lordship. Our Honorable High Court has already held in this in the case of Madhav Sutradhar, Lordship.
okay, I'll consider all these aspects from the side.
Lordship.
Okay. Item 19 and 20. I'll record your senior name.
Lordship. My senior is out of station, Lordship.
I'll record his name, otherwise.
I leave it up to your Lordship.
Okay, please write both the writ petitions.
One aspect, that vice chancellor's, the university's affidavit, page 406. Also, just 2 lines.
Vice Chancellor's
Register of the university,
page.
406, relevant. It starts from page 400. Your Lordship got it.
Yes, 400.
Your Lordship comes to 406, relevant portions. After about 3 lines. However, it is not possible for the screening committee to precisely determine the quality of each and every research publications of a large number of candidates. So screening committee or the scrutiny committee, whatever they call it, my lord, whatever they say, it cannot be end all, my lord. It can be challenged. Scrutiny committee is there, constituted as per law. But whatever the constitution, my lord, the committee says it is not the end all matter. It can be challenged anywhere, man. I come to High Court, I go to director, I go to secretary. The allegation which has been brought in, my lord, is a very serious allegations. And your lordship will kindly see only one aspect of the matter, the research paper submitted by the respondent number 8. I'll just publish page 82. Man. Page 82. Whatever paper they will submit, it is not peer reviewed or UGC care listed. No, let me just. Only the cover paper you give it and you show this. Go to the authority and convince them. My lord, page 82, your lordship has seen, my lord.
Yes.
Yes, it is published. International Journal of Research and Analytical Reviews, so and so, so and so, so and so. This is all right. Then come to 90. Come to page 90. This is from page 82 to page 89. This is one paper. And from 90 onwards, all the papers which are there ensure quality of higher education in where it has been published. Below, your lordship will kindly see, nothing is there. Now they have, what they are showing is that some cover page they have annexed in their affidavit in opposition to show that it is published in peer reviewed or UGC care listed paper journal. Go and show to the expert committee or to the authority who has given the expert that committee report.
Lordship, that is also there, lordship, if I may be allowed, I can show it. And satisfy.
I'm obliged, your lordship.
Lordship, in my affidavit in opposition, lordship, it is there, it is categorically, all these queries have been answered, lordship. Lordship, my affidavit in opposition, in petition number 598 of 2023, lordship, 24. Respondent number 8, affidavit in opposition, lordship. From page 127 itself, lordship, my application is there, which copy of my application form, which was submitted, is there, lordship, when I have categorically stated. The list is there, lordship, and lordship has found it.
Page 127.
127 onwards, lordship, and more specifically, lordship, it starts from page 139, annexure G, that is annexure G, lordship. On the previous day, when my senior argued, lordship, he had showed it to your lordship. I will again show it to you today. These are the 10 research papers submitted by the writ petitioner.
Yes.
Lordship. So at page 139, lordship, this is the first first copy
No.
of the research article.
Just a
It
minute.
was published in, lordship, may I find it? In a journal called.
You said 127.
No, 139, lordship. From 127, my application starts. All the in the form of annexures. I have annexed it.
The 11 pages 139.
139. From 139, annexure G, it starts. Lordship can categorically see. This is the first page of the journal, lordship. And as my senior has raised this question, the name of the articles are also there. Lordship will find the name of the articles from page number 129, along with the name of the journal. If you say lordship can take 139 and 129 page together, lordship conjointly, if we read it, lordship will get the picture. Where we have stated the pages also, from which page number to which page number, my article is there in that particular journal.
So this will be peer reviewed
All
or
are peer reviewed, lordship.
there's no UGC listed? There are,
UGC listed also, lordship.
The, they comprises,
Selection committee has gone through it, Lordship, and that's why they have given us marks also.
no, at page 129.
Page 129, Lordship, see point
The-
serial number 1, ensuring equality in higher education in rural areas.
The fifth column.
Journal's name is Edward. The title of my article is ensuring quality in higher education in rural areas. And the page numbers are 335 to 340. So like this, Lordship, the list is there. And from 139 onwards, the for cover page of the journals we have annexed, Lordship. And all are peer reviewed, Lordship.
What about serial number 7? This is impact factor. Care list.
Peer list, peer listed or UGC or peer reviewed.
Advertisement says either peer
said.
reviewed or UGC.
Care listed.
Care listed will
Advertisement
be,
says so.
so care listed or impact factor will be considered as what?
As the criteria for selection for giving marks, Lordship, eligibility criteria to sit in the interview, Lordship.
You only pointed out the qualification. Minimum 10 research publication in peer reviewed
Lordship,
or
or
UGC listed journals.
Lordship.
So the remarks given here is impact factor 7.97. What does it mean?
Lordship, may kindly see that cover page of this article, Lordship, Madhya Pradesh Journal of. There it will be written, Lordship. We have submit.
Where is that?
One, two, three, four, five, six, seven.
145. 145.
Lordship, you kindly see the page number in 145. It is written peer reviewed journal of MP Institute of Social Sciences Research. So it is also a peer reviewed journal, Lordship. Lordship, what happens is when there is a panel of in the editorial board, if there are more than 5 or 6 persons, then it is known as peer reviewed, Lordship. Generally in academic criteria.
And the other?
Other, Lordship, this Madhya Pradesh, Lordship, this is a peer reviewed journal. I
No.
don't know.
In peer reviewed,
It is
that is
peer
the,
reviewed, Lordship,
that
but
is the, that
here
is,
in the comment section, they have written.
that is the position.
5.3 and care listed.
No, you said when there are more than 5 editorial board
That
members,
That Lordship.
that's called peer reviewed,
Peer reviewed, more than 5.
more than 5. Then what about UGC listed journals in that case?
UGC listed, Lordship, UGC maintains that's the any council of UGC can give more light into it. But in my humble understanding, Lordship, UGC maintains a list of, I think now also it is defunct. There is no more UGC care list is no more, but still, Lordship, UGC used to maintain a list of journals. UGC themselves, they set some criteria, benchmark. If those journals, they qualify those criteria, then they become eligible to be listed in the UGC care list.
All right.
Lordship. And Lordship, if I will rest my case, Lordship, if the re-verification committee is allowed, Lordship, then it will open a Pandora's box. Everyone will come, if unsatisfied candidate will come and raise question, Lordship. And the basis of this kind of re-verification committee, the purpose of the selection committee will be nullified, Lordship.
Oh. Okay.
Sorry, my lord, my lord, just for a moment, my lord. 394, your lordship has seen, page 394.
394.
This is the expert committee thing. And if he has got to say truth, he'll give a go again. No. I said, if he has something to say, let him finish it, my lord. Page 394.
Your Lordship got it.
Yes, yes.
Yes, this is the report, my lord, expert committee report. It says, I'll just read one sentence, my lord. One or two sentences regarding research papers of Dr. Pratibha Patwari, petitioner in the other case and respondent number 8 here, has submitted 10 research papers, and out of this only one paper has been published in the UGC care listed journal, which the UGC's affidavit also says, and is valid for consideration. Another 4 papers are neither published in indexed nor in peer-reviewed journals, and hence may be rejected. The peer-reviewed status or validity of remaining 5 papers could not be confirmed due to lack of pertinent information. Now, next page, your worship. These are the papers of the respondent number 8, and second is the list of papers submitted by the present petitioner. Your Lordship got it. Page 395 is the paper submitted by the Pratibha Patwari, and page 396, the paper submitted by the present petitioner. Now, page 397, your Lordship will kindly see. 397. Your Lordship kindly see, this is the report of the committee for re-verification of research papers published in journals submitted by Dr. Patwari and Dr. Pramod Medi for the post. This is first is research paper published by Dr. Patwari. Name of the journals, ISN, journal website, it is there. Scopus index, UGC care listed or not, only one. That your Lordship will get it, page serial 7. And peer reviewed, nothing is there. Could not be assessed, could not be assessed. Journal claim to be peer reviewed. However, in reality, it is not peer reviewed. Has your Lordship got the comments? So all whether UGC care listed, only one. Whether UGC peer reviewed, nothing is there. So therefore, out of 10, only one UGC care listed is there. Others are could not be assessed, and could not be assessed. And page 399, my lord. This is in respect of the lead petitioner. Peer reviewed and UGC care listed, it is mentioned.
Okay, Mr. Das.
My lord,
Consider.
deeply obliged. Rightly or wrongly, that experts committee findings stands in the absence of any challenge. Deeply obliged.
Please write, both the writ petitions are being disposed of by this common order. Since the issues involved are similar. The matters were taken up for hearing on 22/7/2025. Comma 28/7/2025. and thereafter today. Stop. I have heard Mr. B.D. Das, Learned Senior Counsel, assisted by Mr. HR Das, for the petitioner in WPC number 598 of 2024. And Mr. K.N. Chaudhary, Learned Senior Counsel, assisted by
Dr. P.P. Medhi, Lordship.
Dr. P.P. Medhi, for the petitioner in WPC number 3543 of 2023. Stop. I've also heard Mr. S. Bora, Learned Standing Counsel BTC, for the BTC respondent, Mr. UGC, Mr. S. Bhuya, Learned Standing Counsel Higher Education Department, for the state department. Then Mr. V.K. Borua, Learned Standing Counsel, Learned Counsel for the Boroland University respondent. It's okay. And Mr. R. Bhuya, Learned Counsel, appearing on behalf of Mr. A. Shamua, Standing Counsel, UGC, and representing the UGC respondent. We'll stop. Next para. Oh, sorry. Also had Miss R. Deka, Learned Counsel, appearing for the, what is the full form? Full form. No, that governing body. Learned Counsel appearing for the governing body Goreshwar College. What is the full address? Goreshwar College of which place? Goreshwar. Goreshwar College, Goreshwar. Next para. The instant controversy revolves around the filling up of the post of principal, Goreshwar College, Goreshwar, on regular basis. Stop. An advertisement was floated in the local daily dated 1/1/2023, inviting applications from eligible candidates having the qualification for the said post. With supporting testimonials from HSLC onwards. Stop. For the purpose of the instant case, the controversy involved can be narrowed down for consideration on two main conditions given in the said advertisement. To stop, the first being condition number 5, which provides that a minimum of 10 research publication in peer-reviewed, PEER, peer-reviewed or UGC listed journals and a minimum of 110 research core is required as per Appendix Roman 2 at table number 2. Stop. The second condition relevant is condition number 10, which provides that preference shall be given to the candidates belonging to BTR, Borough Territorial Region, isn't it? BTR full form?
Boroland Territorial Region.
You write full form. Boroland Territorial Region, bracket BTR. Stop. Pursuant to the said advertisement, candidates eligible for the post applied submitted their application, not applied, submitted their applications, including the petitioners in both the cases. Stop. Interview was held on 6/4/2023. And out of the 3 candidates who were called for interview, one was absent. And both the petitioners in the 2 cases appeared for the interview. Stop. As per the marks scored by the petitioners, these are only interview marks. This is interview marks only, isn't it? The petitioner in WPC number 3543 scored a total of 427.4 marks with an average of 61.05. While the petitioner in WPC 598 of 2024 scored 400.58 marks with an average of 57.23 marks. Stop. The selection the selection committee by resolution number 1 selected the petitioner in WPC number 3543 of 2023 for appointment against the post concerned based on the performance in the interview held on 6/4/2023. And further resolve that the resolution of the selection committee be forwarded to the governing body for its approval and necessary action for appointment. Stop. A special meeting of the governing body, Goreshwar College, was convened on 16/4/2023, wherein the governing body resolved to appoint the petitioner in WPC number 3543 of 2023, who was selected no.
Just forwarded the.
No, I'm reading that literally, I'm dictating what is written in the,
Yes.
who was selected as first position by the expert committee of Borland University. For the post of regular principal, Goreshwar College. Stop. So by the said resolution, it was also mentioned that the petitioner in WPC number 598 of 2024 who has secured the second position is a permanent resident of BTR area. Now, accordingly, the principal in charge / governing body president was authorized to submit the proposal to the Director of Education, BTC, for necessary action. Stop. Pursuant thereto, the Director of Education, BTC, by order dated 10/5/2023, appointed the petitioner in WPC number 598 of 2024 as regular principal of Goreshwar College, Goreshwar, with effect from the date of his joining the said post. Stop. Aggrieved with the same, the petitioner in WPC number 3543 of 2023 submitted his representation. Pratibha, this lady, isn't it? Submitted her representation before the Secretary, BTC, Kokrajhar, Assam, as well as the Director of Education, BTC, Kokrajhar, Assam, on 15/5/2023. Praying for reconsideration of the approval given by the Director of Education, BTC, in view of the fact that she was selected in the first position by the selection committee. Stop. Since the same was not considered, the said petitioner filed WPC number 3543 of 2023. Next para. The said petitioner, by relying upon the marks allotted by the selection committee, as well as the resolution of the governing body of the college, namely resolution number 3. Has claimed that the petitioner in WPC number 3543, I'm sorry, WPC number 598 of 2024 could not have been appointed since she was found to secure the first position, scoring more marks than the latter. So further, clause 10 of the advertisement would not have been put into operation in view of she having scored more marks than the latter. To stop against the said writ petition, the respondent governing body, Goreswar College, as well as the private respondent number 7, who is the petitioner in WPC number 598 of 2024, filed their affidavit in opposition. So likewise, respondent number 4, who is the Director of Education, BTC, also filed counter affidavit. To stop in all the affidavits filed, stand taken is that the private respondent number 7 and the petitioner in WPC number 598 of 2024, being a local resident of BTC, has been given the preference in terms of clause 10 of the advertisement, and therefore there was no irregularity in giving him the appointment. Next para. It may be stated herein that the private respondent number 7 comma not comma, just continue. Private respondent number 7, in whose favor the appointment order was issued, also filed a writ petition, that is WPC number 598 of 2024, by making the petitioner in WPC number 3543 of 2023 as respondent number 8. So in his writ petition, the petitioner has challenged the eligibility of the respondent number 8 slash petitioner in WPC number 3543 slash 2023 to participate in the interview for the post of Principal Goreshwar College. In view of the prescription made in the advertisement, and importantly, in view of what has been stipulated in clause number 5 of the advertisement dated 1/1/2023. Stop. In other words, the said petitioner contends that the respondent number 8 could not fulfill the basic requirement of minimum of 10 research publications in peer-reviewed or UGC listed journals and she could not fulfill minimum of 110 research score as per Appendix Roman 2 at Table 2.
That not facing, only research paper. And minimum research score and have not submitted before.
Only peer-reviewed.
It doesn't have the quality. Eligibility.
But this is what you have stated
Yes, I've stated, my lord.
in paragraph 13.
Yes, but in the course of hearing, my lord, I have not pleaded that and I do not want to press that because I do not have documents to show that. So
Appendix
unnecessary.
Table 2. Open bracket. Insofar as the non-fulfillment of the minimum score, minimum research score as per Appendix 2 at Table 2 from the learned senior counsel for the petitioner. Do not press the same, close bracket. Therefore, the acceptance of the candidature of the respondent number 8 for the post of principal in question is ex facie arbitrary and in violation of the eligibility criteria stipulated in the UGC regulations 2018, published in the Gazette notification dated 18/7/2018. Stop. As for the said petitioner, he had submitted 20 numbers of research papers along with other research works fulfilling the requirement of regulation 4.1 Roman 5 capital A bracket Roman 3 of the UGC guidelines 2018. To stop, the said petitioner also contends that in view of such discrepancies, in view of such shortcomings, which the petitioner detected after applying for information through RTI, submitted a representation, submitted his representation before the Vice Chancellor, Bodoland University, as well as the Director of Education, BTC, on 1/2/2024, with a request to inquire into the anomalies in regard to the selection process of the post of principal, Goreswar College, Goreswar. This inquiry came later on, isn't it, Mr. Das?
Yes,
Writ petition was filed without that inquiry report.
yes,
During the pendency,
Yes, yes.
in their affidavit, inquiry came.
yes. Our whole contention is that we have filed a representation that should be looked into and the whole allegation is that he doesn't meet the requirement of the UGC regulation.
That is the repetition.
Okay, stop. Since
So we can go the court.
there was no response from the authorities concerned, the petitioner initiated his writ petition. By filing the same on 6/2/2024. So in response to the writ petition, next para, just the private respondent number 8, who is the petitioner in WPC number 3543. Filed his counter affidavit. Filed her counter affidavit denying the allegation made by the petitioner. Contending inter alia that she had secured the first position in the selection process and that she has secured 10 of her research papers published in peer-reviewed or UGC-listed journals. Which she had clearly mentioned in part capital B at page 3 and 4 of our application form dated 13/1/2023. And that the 10 research papers with cover page of the journals have been submitted along with the application form mentioned in at serial number 20. Of the contents from page 37 to 155. Stop. In other words, she having clearly fulfilled the criteria stipulated in the advertisement as per the UGC regulations, and also having scored more marks than the writ petitioner, she ought to have been appointed the post of principal of Goreswar College. Stop. To support her statements, respondent number 8 annexed the contents of the application form bracket part A and part B to the affidavit. The University Grants Commission, who was subsequently included as a party respondent number 10 to the writ petition also filed their counter affidavit. Giving comments. On the list of publications submitted by the two writ petitioners. With a specific statement that UGC refrains from making any comments on the research articles which are claimed to be published in peer-reviewed journal because no such record of such journals are on its database. The next para, the director of BTC arrayed as just 2, 3, 4, 2, 3, 4. On behalf of itself as well as on behalf of respondent numbers 2 and 3 filed counter affidavit stating that preference can be given to candidates belonging to BTC as per paragraph 10 of the advertisement. And as regards the publication of research papers by the petitioner as well as the respondent number 8 in peer-reviewed or UGC listed journals, the BTC constituted a committee, write BTC notification under memo number BTC/EDN-133/2022-23/PRR PT dash Roman 2 slash 635 dated 4/4/2024 for re-verification of research papers published in journals submitted by the petitioner and the respondent number 8 for the post in question. So a meeting was conducted on 1/4/2024. And accordingly, the minutes was drawn stating that respondent number 8 had submitted 10 research papers. And out of this, only one paper had been published in a UGC care listed journal and valid for consideration. Stop. Another 4 papers are neither published in the index nor peer-reviewed journals and hence liable to be rejected. Stop. The peer-reviewed status or validity of the remaining 5 papers could not be confirmed due to lack of pertinent information. Stop. As for the writ petitioner, he had submitted 20 papers, and out of which 18 papers were valid for counting. Stop. 5 papers were published in Scopus dash indexed journal and 13 in peer-reviewed journals. Stop. The remaining 2 papers are not published in peer-reviewed journals and therefore liable to be rejected. It may be stated herein that the findings of the said committee is subsequent to the filing of the writ petition. And that no steps in terms of the findings of the committee has been taken. Since the court is in session with the matter. To stop, the respondent BTC to support their contentions annexed the meeting minutes to the counter affidavit. Next para. The respondent number 5 and 9, which is the Borderland University, have also filed their affidavit in opposition. Contending that the post of principal was advertised in accordance with the Assam College Employees open bracket provincialization close bracket rules, 2010. Stop. That selection committee was constituted in terms of the relevant rules. This university is not a party in the other case. In the later case, not in the earlier case.
No, Lord. No, in other case, no.
The UGC regulations on minimum qualifications for appointment of teachers and other academic staff in universities, 2018, prescribes the minimum eligibility criteria for appointment of college principals in Regulation 4.1, and that the research publications as well as qualifications of applications of applicants must conform to the standards prescribed therein. Of the screening committee constituted for the purpose inspected the research papers of all the applicants and duly verified their authenticity of their research publications prior to awarding research course in accordance with the norms prescribed by the UGC regulations of 2018. Stop. It is, however, stated that though the screening committee meticulously inspects each and every research publication to ensure that they conform to the norms and standards prescribed. But it is not possible for the screening committee to precisely determine the quality of each and every research publications of a large number of candidates. Stop. In the instant case, the screening committee evaluated all applications received in accordance with the provisions of UGC regulations 2018, and that there is no illegality and biasness in such evaluation. Stop. The university further has contended that out of the 4 disputed research publications of respondent number 8, what did I say? Submits that out of the, not out of the, submits that the 4 disputed research publications of respondent number 8 have been found to be published in journals that are peer-reviewed / refereed journals, and research course to these publications were allotted in accordance with the criteria prescribed in Appendix Roman 2, Table 2 of UGC Regulations 2018 after due verification. Stop. In support thereof, a chart indicating the manner in which the same are accepted as peer-reviewed, etc., has also been demonstrated in the affidavit in opposition. This affidavit reply we have filed. The affidavit reply you filed on 25th of July.
Our reply, Lordship.
Yes, your reply. This is against the affidavit in opposition filed by respondent numbers 2, 3, and 4. All of you are respondents.
Yes, Lordship. UGC,
So between the respondents also you can reply like that. You are respondent number 8, isn't it?
respondent number 8, Lordship.
8. You're respondent number 8.
Lordship.
So the other side has filed writ petition, you file a affidavit in opposition. But then the director of VTC also files a counter affidavit to that writ petition. They are the respondent numbers 2, 3, and 4.
Lordship.
Now you file a reply to their affidavit in opposition, but you are not the petitioner. You are also one of the respondent.
Lordship. We have filed an affidavit.
What is this concept? I have not understood this.
The last occasion, our senior said we will file a reply. That's why we filed.
No, you may
To be
file.
on records, Lordship.
I don't know. I don't know. Because you are also a respondent. They are also a respondent.
Lordship is very much correct, Lordship. Just in order to bring on record those aspects.
Okay, next paragraph. To respond to the affidavit in opposition filed by respondent numbers 2, 3, and 4, the private respondent number 8 filed an affidavit reply on 25/7/2025. Questioning the validity of the committee constituted on 4/4/2024. In view of the fact that the members of the committee were said to be involved and instrumental in the illegal appointment of the writ petitioner to the post of principal, Goreshwar College. Of the chairman of the governing body. Now, the chairman of the re-verification committee had recommended, had influenced Jagadish Brahma. Who is he?
Amarjyoti.
Jagdish Brahma. He is the chairman of the.
Borman is the chairman.
No, Jagdish Brahma.
Is the director.
Jagdish Brahma.
He is the director of education.
And Amarjyoti Burman.
Amarjyoti Burman is the secretary of the secretary of the BTC, and he holds the portfolio of the education.
What did I say? No. He was the chairman of what? Re-verification?
Yes.
The chairman of the re-verification committee, also the secretary, education, BTC, had influenced the director of education, BTC, to appoint the writ petitioner. And therefore, the re-verification is not acceptable. Next para. Parties concerned. The learned senior counsels appearing for the respective petitioners, as well as the departmental counsels, have made their respective submissions. I think I'll continue this later on. I'll keep the CAB. I have no option. Now, a few more lines. Next para. Mr. K.N. Chowdhury, learned senior counsel, has argued that the appointment of the petitioner in WPC number 598 of 2024 as principal of Goreshwar College cannot be sustained in view of the fact that the petitioner whom he represents was declared to have secured the first position by the constituted selection committee. Having scored 427.4 marks over 400.58 marks scored by the latter. Stop referring to the stand taken in the affidavit in opposition of the respondents. The learned senior counsel submits that invocation of clause 10 of the advertisement dated 1/1/2023 can be done only when all things are equal. Stop. Since the petitioner whom he represents has clearly scored more than the private respondent, clause 10 cannot be attracted. Stop. In support of his submission, the learned senior counsel has relied upon the case of Dr. Madhav Sutradhar versus State of Assam and 6 others. This is not reported. Then you write like this. Has referred to an order passed by the has referred to order dated 22/1/2025 passed by a coordinate bench of this court in WPC number 2776/2024, open bracket, Dr. Madhav Sutradhar versus State of Assam and 6 others. Comma, the case of G. Jayalal versus Union of India and others, reported in 2013, 7 SCC 150. Comma, the case of Secretary AP Public Service Commission versus YVVR Srinivasulu and others, reported in 2003, 5 SCC 341. I think that's it. There's 3 cases. Then you put and. Okay. 1, 2, then number 3. Before that, you put and. Of the learned senior counsel, in response to the challenge made by the petitioner in 598 of 2024, insofar as the requirement of having a minimum of 10 research publications in peer-reviewed or UGC-listed journals is concerned, where is that affidavit? Submits that
It is at page 115.
This 115. Okay, yes. Submits that the petitioner he represents has got hard 10 research papers published in peer-reviewed or UGC listed journals, which she has clearly mentioned in her application form dated 13/1/2023. And she has also submitted the cover page of the journals in support thereof. So he submits that the cover page of the journals clearly show whether the journals is peer reviewed or UGC listed and its impact factor. So the total research score of the deponent comes to 434.5. The learned senior counsel submits that at any rate, it is not open for the private respondent to make a challenge. To the assessment made by the selection committee by filing writ petition. Belatedly. Since recommendation was made in favor of the petitioner he represents as far back as on 6/4/2023. He submits that the writ petition filed by the private respondent number 7 is only to counterblast the legitimate claim made by the petitioner and not for any other reason. He submits that the recommendation made by the constituted selection committee having held the petitioner to have secured the first position supported by appropriate marks, the appointment of respondent number 7 should be set aside. And the petitioner, he represents, be appointed to the post in question. Next para. I think I'll stop here, Mr. Das. I'll continue later on. I'll stop here. Heart separately, right? Heart so and so, the parties are there. Hearing concluded, judgment is.
Oblige. Oblige, Lordship.
Just hold on. This is page 001.
Please, your Lordship.
Yeah, just a minute, okay? Yes,
My lord, I have filed a petition, my lord. Flag Y, my lord.
you are for which respondent?
My lord, governing body. Respondent number 3, my lord.
Uh-huh.
And I have filed this petition to allow me as an advocate representing the respondent number 3. I have filed this application for withdrawal of Waklat number 5.
For withdrawal.
Withdrawal.
Otherwise, you are appointed to appear on behalf of.
Respondent number 3, my lord.
There's one number 3.
Equity of the codex for particular matter.
Okay. Now you want to withdraw.
Yes.
Why you want to withdraw?
My lord, some differences arises between the president of the governing body and myself. Lordship, if kindly produce last order, Lordship will. He lodged a complaint against me, my lord, in respect of the additional filing of additional affidavit. That is why I am going to withdraw myself in the matter.
There is one letter also earlier, isn't it? Some
Yes, my lord.
written to the Joint Registrar Judicial. Yes, you are for the petitioner.
Yes, on behalf of Mr. Puya, I am appearing petition.
So what is to be done?
So, if he's withdrawing, then it's up to him, Lordship, what have we got to say on this? Perhaps the concerned respondent may engage some other counsel.
No, simple withdrawal is okay. That can be permitted. But there is one more letter
Yes.
written by that person. I mean, who's that person who written?
Regarding that aspect on the last occasion, Lordship, at ours, Lordship,
Some allegation is made.
perhaps.
Allegation made against you.
But I was not permitted to engage my senior counsel as doctor or
forging his signature, etc.
Signature was forged.
No, my lord. Never, my lord. Actually, what happened, my lord, in this case, my lord, there are as many as 5 writ petitions pertaining to the selection and appointment of for the post of the principal. My lord, the writ petitioner withdrawn, except this writ petition, all other writ petition were withdrawn by the.
That is
writ
because
petitioner.
the cause of action
And
has
all,
lapsed, lordship, that is the reason.
my lord, the governing body filed detailed affidavit into writ petition, that was withdrawn. Then, my lord, there was a discussion to file a fresh and additional affidavit, which are not available in the present writ petition. That is why an additional affidavit was filed by the respondent number 3, submitting all the relevant documents pertaining to the present writ petition. And that's may perhaps, my lord, not suitable to, it become not suitable to the, my lord, my client. And therefore he asked me,
That's why he alleges that it was not he who filed it. Somebody else filed it.
that is the allegation.
That is why.
But there was a proper conversation.
Hmm. Signature seems to be okay, although we are not expert. I've seen it.
Not in this case, my lord, the other petition also, which were earlier withdrawn, my lord. My lord, WBC 4073 of 2019, 4137 of.
Okay.
2020.
Okay, you want to withdraw? We'll allow you to withdraw then.
Right.
Mr. Counsel,
NZ Chaudhary.
any objection?
No, sure. I have no objections up to him and his client, lordship.
Your good name?
J.H. Soikia. That is-
J.H.
Yes, ma'am.
Mr. J.H. Soikia, learned counsel for respondent number 3, submits that he would like to withdraw his wakalatnama for appearance on behalf of respondent number 3. Since some differences have arisen between him and his client. Most of the learned counsel submits that he has also filed an application for leave to withdraw his wakalatnama. What is this provision? Rule 67, chapter 5.
Yes, ma'am.
Give me that Guwahati High Court books. Chapter 5. He has also filed an application under rules 67 of chapter Roman 5 of the Guwahati High Court rules, praying for leave to withdraw from the case. Yes, your good name?
NZ Chaudhary.
Mr. N.Z. Chaudhary, learned counsel for the petitioner, submits that he has no objection to the same. And that the matter is entirely between the counsel and his client. And he has nothing to say.
Yes.
Next paragraph, it is also seen that who's respondent number 3? President.
President of the governing body.
The incumbent president of the government body of Barkhetri College, bracket respondent number 3, has submitted a letter dated 16/6/2025 before the joint registrar, bracket judiciary. Making a complaint against Mr. J. Saikia, Lanet Counsel. Stop. Be there as it may, having considered, having regard to the application filed by the learned counsel to withdraw himself from the case, and the enclosed annexures to the said application. He is allowed to withdraw himself from the case. Registry to strike off the name of Mr. J. Saikia as the counsel for respondent number 3. Next para, insofar as the complaint submitted by the respondent number 3 on 16/6/2025
That part, that affidavit part, you have to constitute the inquiry, yes, because lordship, he has filed the affidavit lordship, his signature is there lordship. Now, some reason he came before this honorable court by giving a representation to the registry that he has not filed it. Something is there lordship. So lordship may give an inquiry in part, in that respect lordship. And even lordship may send it for forensic also lordship. Regarding that part, it's not a lordship simple issue lordship, it's a serious issue lordship. He is committed for, if he is filed this affidavit lordship by his own signature, then he is committed for against the court as well as the lawyers also lordship, whom he has engaged lordship. She may send a signature for forensic lordship. That part lordship may constitute the inquiry committee lordship. Then lordship may send it for after the lordship. Otherwise lordship, it's not an easy thing lordship. All persons are playing with the court lordship. Today he is come, another day again one person is come. Sometimes he against the petitioner, now he is in the favor of the petitioner. Something is there lordship. That college is lordship, their long history lordship.
More than lordship, 50 repetition is pending before this honorable court. By this side or that side, lordship. Not only this person, this petitioners himself more than 20 returns pending. lordship. If Engaged Counsel done something, he has committed serious lordship, professional misconduct, lordship.
No, that is there.
It is there.
See,
But
there is another option.
Otherwise, lordship, that part, as we know, lordship, as the litigation is going on, we are in that side, lordship, I know him, lordship, he is filing various affidavit on behalf of that particular president also, lordship. At no point of time that allegation was done. Now something is developed, some development is going on, so that thing is done, lordship. Otherwise, he will not do that such type of things. We have the faith, lordship. He is filing the affidavit on behalf of the college side, not only this case, lordship, several cases. More than 20 cases he is representing the college, lordship. Not a single point that allegation has come. And that particular person is invoked the president post also. So lordship may give the inquiry, lordship. That particular point, lordship, whether actually he has signed or not, whether some commit or wrong was committed by the council side or his side was. If he is playing with the court, then lordship serious things happen. And this kind of indulgence, lordship, we cannot do. Otherwise, lordship, the other days, some people are come.
What did I say last? Regarding the forgery of the signature of the respondent number 3. Oh. Okay, I'll pass necessary orders. Some inquiry will be done. I'm not very sure about the constitution of that inquiry. I'll find out and.
Side of the judicial lawsuit may direct the administrative side of the judicial lawsuit.
Partner, my lord, regarding forgery of college seal also. There is a allegation. But here is no seal is used in filing affidavit. He simply stated that my seal and signature has been forged.
Okay.
Otherwise, on behalf of that particular person, he has filed lawsuit so many affidavits. We have done so it lawsuit. More than 30 cases is still pending in this particular college.
Okay, otherwise, what is the stage of this case then?
It's pending for hearing. lordship.
No, pleadings are complete, otherwise.
Otherwise,
Okay.
complete.
Okay.
Because,
At first, settle this particular issue also.
and otherwise, there was some urgency on our part to get the matter hard.
Oh, the matter will be looked into. Let's see.
Yes, lordship.
It will not take a very long time.
God bless.
I'll pass necessary orders.
Sure.
You type out what I have given you, no? I decided to leave you the file. Yes.
Offline.
It will also, it will take lot of time, so now it's 4 hours. It will take time.
So when will be convenient? We'll give you a date then.
As and when lordship is available.
Any urgency?
No man.
Post it after 2 weeks. Let that registry fix a date. Or straightforward is the matter again after 2 weeks on a date to be fixed by the registry.
My lord, if possible, kindly mention the date of.
Date they will give you.
Obliged.
Only.
Obliged.
23 also, it will take time, for this after CAV, the matter was lawsuit come up. The matter
Let's
was finally heard lawsuit, both sides have hearing was concluded lawsuit. It was for judgment lawsuit.
You want a specific date? I'll give you a date for this.
My lord. I am for the petitioner. My lord, I sometime is dear, my lord, should I start, my lord?
Or today it is not.
No,
possible.
not now. Only when we can somehow complete, we'll start. Otherwise.
My lord,
difficult.
yes, my lord.
After 2 weeks,
My lord. Date will-
similar order, huh?
No, I should come on.
Registry will fix. After 2 weeks, they'll give you a date.
My lord. Should not be, my lord, on 5 to 7 September, my lord. 5 to 7 September, I will not be available. Any other day.
7 September.
5 to
5th will not be possible Friday.
my lord.
6th not possible Saturday.
My lord.
7 is Sunday. Don't worry, it'll not be fixed on Sunday. We also don't want Sunday.
11.
Sir, registered you.
Yes, ma'am.
On a hearing date, they'll.
My lord. My deep level.
Kindly see the last order, my lord.
I've seen it. But probably we should not have passed that order also. What is to be done? Court says that list this so and so of 2022 along with so and so, one so and so. This order should go in that case, not in 21. This is 2021.
Yes.
Isn't it? So what can be done?
And in this case, BDC file affidavit, my lord. But they say that our role is limited. They have done verification.
No, this is not your case. This is WPC 6731 of 2021.
Yes.
Your case is which one?
Yes, I don't know 21.
Case number.
6731 2021.
Or 21.
Yes.
Then you see the last order, we say that the correct case was 2022, not 2021. On the last occasion,
Can I verify that?
you just have a look. On the last occasion, yes, call the other. None appears for the petitioner when the matter is called. Yes, the matter again after 4 weeks on a date to fixed by the registry.
Make pleasing motion. But here in this case, I was given the charge of in-charge headmaster. But by impugn order, my lord, that is at page 40. That charge has been taken away. But here, my lord, my submission before your lordship is this. That charge given and charge taken, that can be. But in the impugn order, some allegation has been given to me that I misappropriated the amount of the school and other some allegations, my lord. So, my lord, my humble submission before your lordship. It is not an order simpliciter. It's an order whereby stigma has been given to me. If there is anything, there should be a departmental proceeding. There should be a suspension against me. Without that, my lord, your lordship would be pleased to see page 40.
Mr. Sheikh,
My lord,
we'll have this matter some other day.
my lord.
It'll take some time.
So, my lord, your lordship, the order was passed on 28/5/2024. So, my lord, more than 1 year, I am fighting before your lordship to get this order set aside. My lord, if your lordship please, because it is.
My lord, here I am appearing for the president of the SMDC, my lord. Lordship, may kindly schedule this communication, my lord. By which, my lord, there is an allegation of misappropriation of government fund against the petitioner, my lord.
My lord, that I agree, that there is allegation.
And my lord, in this regard, my lord, audit inspection has already been started, my lord. So, Lordship, may kindly peruse, my lord. On 21st of March 2025, my lord, the communication was made.
Audit is
going
started,
on,
my lord, that is to be said by the director, not by the SMDC. It is the business of
My
the
lord, I will
SMDC. Order was passed
in
by
my
the
affidavit,
director.
my lord, the allegations, my lord, against the petitioner, my lord, after taking the charge of, my lord, he was not given the, my lord, only given the charge of, my lord, additional charge of headmaster, my lord. And it was purely a temporary basis, my lord. So when the allegation of misappropriation of fund, taking money from the parents in the name of passing examination, he has enhanced the examination.
So many allegations is there, my lord. So many allegations
my
is
lord,
there. That
inquiry
is to be
was
proved. That is to be
Please let
proved.
me
Without
complete.
proving that,
My lord,
without
the
suspending me. Why they did not suspend me? If I am so bad man.
That's why, my lord, audit inspection is going on, my lord.
Misappropriation against me. I am embezzled the fund of the school, do many wrong things. I am a government
And my
servant.
lord-
I should be placed under suspension. But stigma has been given without any show cause, nothing of the sort.
My lord, show cause was given, he.
No,
also filed
that
his reply, my
show
lord,
cause will not
inquiry was-
do. I am
inquiry
a
was
government
on my
servant.
part, my lord, I will show, my lord, in
And
my.
your
affidavit.
lordship, what SMDC has to do, it is the
Yes,
government
you-
servant, director is the authority.
My
He
lord-
passed the impugn order. He is to come.
He, my lord, the.
He,
petitioner, my lord,
SMDC,
he being the, my
what
lord,
SMDC is against me, man.
in charge headmaster, my lord, he compelled
That
the,
also
my lord,
acts as the SMDC.
president of the SMDC to sign the, my
Not
lord,
president
blank check, my
SMDC,
lord.
my lord. He is defunct
Yes, my lord.
SMDC.
I will show, my lord.
He
Whether
is
I
a
am
defunct,
president of the SMDC or not,
defunct
my lord.
SMDC is strongly saying against me, my lord.
Okay, so we'll have a date some
Malad-
other day, not today.
Some other day, my lord.
He has
my
no
lord.
locus tendency to say like this.
Yes.
I am a government servant, government will look into. It's a defunct
Due to
SMDC,
paucity of time.
now
matter
raising
will
his
not be
voice
taken
in the
up today.
court of law.
I will show, my lord.
Registry, please the matter
What
again after
you
2
do?
weeks on a date to be
I am a
fixed
government servant, government will to take.
by issue.
Malad, date has been given, Malad, a date may be given, Malad, both the 1 year.
After 2 weeks,
After 2 weeks,
They'll give a date.
A date may be fixed, Malad.
registry will give you a date.
my lord. Fact file, my lord.
Huh?
Fact.
This is correct file.
This is correct now.
So the order is not correct then.
No, last time what had happened, Madam, last time,
Yeah.
the 2022 file has came, and therefore this order was passed. It ought to have been 2021, but it was listed 2022 repetition. Numbers got confused because of the year.
But,
Numbers was,
but this other writ petition has not been clubbed together, isn't it?
that is not club.
That is not required also.
Not required.
I'm praying for 2 weeks time.
What?
To file my approval. Here, initially, the instruction which we have received, as per our instruction, that the matter falls within the jurisdiction of BTR, the district Kokrajhar. But now BTR has filed an affidavit saying that it is within the jurisdiction of state government. The verification was, the regularization issue come to the MB.
You are for?
I'm for the Department of School
Elementary,
Elementary,
2 weeks.
2 weeks, sir.
That's made for by Mr. B. Kaushik, Learned Standing Counsel, Elementary Education. 2 weeks time is granted, filing affidavit in opposition. Stop, Mr.
Yeah, there you go. On behalf of
B.
Number 456.
B. Hazarika,
On behalf of
Learned Counsel appears on behalf of Mr. R.K. Musari, Standing Counsel, BTC, representing respondent numbers 4, 5, 6, and 7. Mr.
HR Ahmed.
H.R. Ahmed, Learned Counsel appears for the petitioner. List again after 2 weeks on a date to be fixed by the registry.
Obligation.